सब लोगों को नमस्कार, welcome. We are starting our meeting today. I hope I'm audible to everybody.
Yes, sir.
Yes, sir.
Very good evening.
Sir. Welcome, sir. And this is our sixth meeting, and we welcome our guest, Mr. Rajiv Ji. And Navneet
Thank you
Ji,
very much, sir.
now you please take over.
Yes,
Thank you very much, sir.
Thank you, sir. Thank you. Good afternoon to all of you. So, firstly, I would like to extend my hearty welcome to all the members who have joined. And specifically, I will, no, this is the time specifically when presently we can say Har Ghar Tiranga Abhiyan is going on. This is a very good, auspicious day, I must say that, because for the first time this time of Abhiyan has been launched. And IIPA is also moving along with this type of Abhiyan. And from IIPA side, we will request all the members to participate in this Abhiyan. This Abhiyan has been launched to celebrate our Azadi Ka Amrit Mahotsav. I hope most of our members have heard about AKAM. I would like to, you can say, welcome Mamta ma'am also. She has also joined. And I would like to welcome Rajiv Ji. He has also joined, our chief guest. Nilesh Ji is joining, just joining. I have just spoken with him, who is our key speaker. No, the thing is that practically you can see the IIPA is organizing various type of seminars on a regular basis to keep our members abreast of the latest developments. Apart from that, whatever the critical issues are there, we try our level best to make the, you can say, specifically our members aware of each and everything with regard to the IBC critical issues. And Mamta ma'am has already taken few of the sessions. Manoj also has taken. Now this is our own member, Nilesh Ji, will be conducting today's session. I'll request Manoj Ji to, before we start the formal proceedings, so just if we can have a, you can say, our national anthem, so that at least we can just move along with the Har Ghar Tiranga Abhiyan, start with that. Manoj Ji, over to you. Thank you, Manoj Ji.
Yes, Navneet Ji. I welcome our guest. He's ex-DGA, Mr. Rajiv Khurana Ji, and his brief introduction shall be given by the host of today, Mr. Navneet Kumar Jain. I welcome Mr. Rajiv Khurana Ji wholeheartedly. And over to you, Navneet Ji. Please carry on.
Yes, sir. So, welcome, Rajiv Ji.
Thank you, sir.
Rajiv Ji has worked with State Bank of India, CBI, I must say, Central Bank of India, not the exact CBI. So He's having approximately 39 years plus of experience. He has worked in various domains of the banking sector. We will definitely get enriched with his experience. And he's having a flair in management audit, especially in forensic audit and resolution of stressed assets through IBC. Look, this is our, you can say, we are lucky enough to have his experiences. He will be sharing his experiences during the various EOC meetings and another things. We are lucky enough. He has experience in OTS settlements besides structuring in as per RBI guidelines. So very vast experience in different domains and specifically connected with our IBC regime. So welcome to you, Rajiv ji. And I will request you to share your thoughts about today's specific topic with regard to, you can say, specifically, I must say, resolution applicants, PRA section 29. And I'll request you to please share your thoughts so that our members get enriched with that. Over to you, Rajiv ji.
First of all, I would thanks to Mr. Navneet as well as to Mr. Manoj, who has given me an opportunity to have an interaction with the elite group of IPs, I can say. So basically, today's topic is related to the section 29A. And I should say that we should read it as A92.
Sir, आपकी फोटो नहीं आ रही and we are missing you, you know, while you are interacting with us.
दिखाया रहा सर, मेरे तो इसमें नहीं आ रहा, पता नहीं क्यों, म्यूट भी नहीं है मेरा और वो भी नहीं है, वीडियो भी ऑन है मेरा.
सर एक बार दोबारा सिर्फ वीडियो को ही क्लिक करके एक दो बार कर लीजिए. I hope it will come.
In the meantime, नीलेश जी नमस्कार.
नमस्कार मनोज जी,
कैसे हैं सर? बढ़िया.
सब ठीक, आप बताएं कैसे हैं?
एकदम बढ़िया, first class, all well.
Welcome Nilesh ji.
Thank you
No,
ji.
now it is absolutely clear.
Just wait a moment. I think our secretary from NCLT, Anupam Lahiri ji, has also joined. Welcome sir. Welcome Anupam ji.
नमस्कार नमस्कार.
IIPA.
नमस्कार अनुपम जी,
welcome to you sir.
नमस्कार.
नमस्कार सर. नमस्कार.
नमस्कार. कैसे हैं नवनीत जी?
बस सर बढ़िया, all well sir, all well. Let us go to Rajiv ji. Rajiv ji, now we are able to view you.
Thank you, sir. Thank you.
So
I said that is we should go in a separate way. That it is the basically it is the section 29A should be read as A92 in a reverse way. It is easy to remember.
Yes.
So if you in the section basically 29A. Basically, it gives us the insight theory that is who are the persons who are ineligible to give their resolution plan as a successful resolution applicant. Basically, there are 8 sub-sets are there who are not ineligible. First of all, the person should not be an undischarged insolvent. Secondly, he should not be a willful defaulter as per the RBI section. And third is basically it is the NPA. In the NPA, it is a very tricky thing. That is basically the many corporate applicants, they want to come take over the other companies, but their own accounts as well as their associated accounts, they are still in NPA. As it in the case of the SR Steel also, you have seen that is in the Uttam Galwa as well as in the that case also, because the Ruya was he was the related person, so he was not able to declare as a, the RP has clearly said that is you are not eligible unless and until you would clear your overdues. And once they have cleared their overdues, only then the resolution plan of RC Mittal was taken into account for the further decision in the matter. Secondly, the persons I have seen that there are persons who are, because there are total 12 schedules are there. In the 12th schedule, it is written that the person should not be behind the bars of 2 years or more. In case he is behind the bars for 2 years, he is not eligible. And in case it is under any other law, if he is having 7 years and more, then still he is not eligible. And in case there is one blue line is there, that is if he has completed his whatever the जो उसको सजा थी वो उसकी कंप्लीट हो गई है, उसके बाद 2 साल का उसको जो है एक तरीके से जो है वो कूलिंग पीरियड है. 2 साल का कूलिंग पीरियड होने के बाद जो है वो एलिजिबल हो जाएगा टू बी एज ए रेजोल्यूशन एप्लीकेंट. उसके बाद कुछ जो है वो अगर मान लीजिए एज पर कंपनीज एक्ट जो है उसके अंदर वो आता है कि भाई वो ही इज नॉट एलिजिबल टू बी ए डायरेक्टर ऑफ द कंपनी, तो भी वो जो है वो रेजोल्यूशन एप्लीकेंट नहीं बन सकता. फिर उसके बाद आता है कि अगर मान लीजिए सेबी ने कोई रिस्ट्रिक्शंस लगाया हुआ है कि जिसके हिसाब से जो है वो पर्सन जो है वो उसके अंदर जो है वो ओपन मार्केट में शेयर्स ट्रेडिंग या कुछ भी जो है वो शेयर्स खरीद नहीं सकता किसी कंपनी के, तो वो भी जो है वो एलिजिबल नहीं होगा. सबसे बड़ा इंपॉर्टेंट पॉइंट है कि वो ऐसा आदमी नहीं होना चाहिए कि जो कि एज ए प्रमोटर हो या एज ए मैनेजमेंट कंट्रोल में हो, या जिसके अंदर जो है वो हमारी जो सेक्शन 43 है, सेक्शन 45 है, सेक्शन 50 है या सेक्शन 66 है, जिसके अंदर प्रेफरेंशियल ट्रीटमेंट्स हो या अंडर वैल्यू ट्रांजेक्शन्स की हुई हो या एक्स्ट्राऑर्डिनरी ट्रांजेक्शंस की हुई हो या उसके अंदर कोई फ्रॉड इनकलकेट किया गया हो और जिसके लिए एडजुडिकेटिंग अथॉरिटी ने ऑलरेडी कोई ऑर्डर पास किया हो. अगर कोई ऐसा आदमी है तो वो भी एलिजिबल नहीं होगा. उसके बाद ये भी देखा गया है सर कि कईयों ने जो है वो मान लीजिए हमने गारंटी इशू की हुई है इन फेवर ऑफ द क्रेडिटर, और वो जो क्रेडिटर है वो भी जो है वो CIRP एप्लीकेशन के साथ लिंक्ड है, तो भी हम जो है वो उसके अंदर एलिजिबल नहीं होंगे. एक तरीके से वो हमारा एक तरीके से वो आ जाएगा कि वी आर द कनेक्टिंग पर्संस. तो कनेक्टिंग पर्सन भी अगर है किसी भी तरीके से अगर वो आता है तो वो भी एलिजिबल नहीं होगा. तो इस तरीके से उसके बाद जो है वो अगर मान लीजिए अगर किसी भी कोई सिर्फ ये नहीं है कि इंडियन लॉ के अंदर ही जो है वो एलिजिबल अगर नहीं है तो वो भी अदरवाइज हमारे को बाहर का भी लॉ देखना पड़ेगा. बाहर के अंदर मान लीजिए इंडिया के अंदर जो है वो कोई ओवरसीज कोई कंपनी है और वो लेना चाहती है, और बाहर उसने मान लीजिए न्यूयॉर्क ट्रेडिंग में स्टॉक एक्सचेंज में वो ट्रेडिंग कर रहा है और वहाँ पे जो उसकी इक्विवेलेंट टू सेबी है, अगर उसने उसको जो है वो डिस्क्वालीफाई किया हुआ है कि वो वहाँ पे शेयर ट्रेडिंग नहीं कर सकती, तो वो भी हमारे लिए यहाँ पे एलिजिबल नहीं होगी. पर अब सबसे बड़ा क्वेश्चन ये आ जाता है कि भाई हाउ वी कैन सी कि बिकॉज द वर्ल्ड इज सो बिग कि जहाँ पे 186 कंट्रीज हैं, तो उसके अंदर 86 कंट्रीज के अंदर कैसे हम अपने आप को जो हमारा रिजोल्यूशन प्रोफेशनल होगा, RP जो होगा वो कैसे उसको आइडेंटिफाई कर पाएगा या कैसे उसको स्क्रूटिनाइज कर पाएगा. तो उसके लिए जो है वो बेसिकली जो है वो क्लियरली कहा गया है अपने एक्ट में ही, इसके अंदर कहा गया IBC में कि आपको जो है वो एक एफिडेविट लेना पड़ेगा उससे सही जो है वो रिजोल्यूशन एप्लीकेंट है कि भाई मेरा जो है वो इस तरीके से कोई भी जो है वो ऐसा कोई भी जो है वो डिस्क्वालिफिकेशन नहीं है, और अगर इनकेस वो कोई डिस्क्वालिफिकेशन आती है तो वो फिर एलिजिबल नहीं होगा. आगे भी फर्दर भी कोई भी रिजोल्यूशन प्लान में अपने आप को वो आगे वो नहीं कर पाएगा, कैरी फॉरवर्ड नहीं कर पाएगा. तो कनेक्टेड पर्सन्स के अंदर जो है बेसिकली 3 चीजें हमारे को होनी चाहिए कि जो रिजोल्यूशन एप्लीकेंट है उसके साथ कोई प्रमोटर एज ए प्रमोटर तो लिंक नहीं है, या एज ए मैनेजमेंट तो लिंक नहीं है, या वो इस तरीके से कर रहा है अपनी पूरी कंपनी का कंट्रोल उसके पास है, यानी उसके पास मोर देन 50% जो शेयर्स हैं वो उसके पास है, एंड फॉर द ऑल द मेजर डिसीजंस आर बीइंग टेकन केयर ऑफ बाय देम. तो वो आदमी भी जो है वो अगर वो इस पोर्टफोलियो में आएगा तो वो एलिजिबल नहीं होगा. उसके बाद हमारा आता है कि पर्सन जो है अगर मान लीजिए ये तो हो गया कि उसने एप्लीकेशन लगाई जब तक, अगर मान लीजिए इम्प्लीमेंटेशन पीरियड के अंदर भी कोई इस तरीके से आता है तो वो भी एक कनेक्टेड पर्सन गिना जाएगा, तो वो भी एलिजिबल नहीं होगा. अब तीसरा पॉइंट आता है अगर मान लीजिए वो कई बार एक 1 लेयर के हिसाब से आ जाते हैं, होल्डिंग कंपनी है, सब्सिडरी कंपनी है, या उसके साथ जो है वो एसोसिएट कंपनी है, तो वो भी जो है वो इस पोर्टफोलियो में नहीं आएगी. यानी इस तरीके से जो है वो आई कैन से कि दैट इज जो जिन्होंने लॉ बनाया है इसके ऊपर काफी जो है वो मेहनत की है. इवन जो है वो जो भी इन्होंने डिस्कशन पेपर भी बनाया है उसके ऊपर भी काफी ज्यादा इसके ऊपर एक थॉट प्रोसेस दिया है, एंड आई अप्रिशिएट द एफर्ट्स व्हिच हैव बीन मेड बाय द लॉ पीपल. उसके बाद जो है अब इसके अंदर कुछ जो है वो अगर मान लीजिए कई आ जाते हैं कि हमारे पास जो है वो बेसिकली जो है वो किसी एक प्लान के अंदर जो है वो रिजोल्यूशन प्लान आया, और रिजोल्यूशन प्लान में जो है वो देखा गया कि वो रिजोल्यूशन प्लान के हिसाब से एलिजिबल था और उसने वो टेक ओवर कर ली है वो कंपनी, और वो दोबारा कोई दूसरी कंपनी लेना चाहती है और उस रेजोल्यूशन प्लान में उसने ये कहा था कि उसका जो एनपीए पोर्टफोलियो है वो उसको 3 साल के अंदर अंदर कंप्लीट कर देगा, तो वो भी जो है वो इसके अंदर एलिजिबल होगा। उसका भी परफॉर्मेंस देखी जाएगी वहां पे कि भाई उसने जो पहले कंपनी टेक ओवर किया है तो उसके अंदर भी जो है वो उसकी परफॉर्मेंस कैसी है। अगर उसकी परफॉर्मेंस जो है वो एज पर द टाइम शेड्यूल चल रही है, ठीक है, तो वो भी एलिजिबल हो जाएगा। और अगर मान लीजिए 3 साल के बदले वो 4 साल के अंदर वो करता है तो देन ही विल नॉट बी एलिजिबल, क्योंकि उसने अपना जो कमिटमेंट किया था वो 3 साल के अंदर उसने अपने कंप्लीट करना था, तो उसने कंप्लीट नहीं किया। उसके बाद जो है फाइनेंशियल एंटिटीज होती हैं, वो भी कुछ जो है वो अपने आप को अंदर जो है वो उनको डालना पड़ता है, क्योंकि बिकॉज जब कोई रिस्ट्रक्चरिंग प्रपोजल होता है या रिजोल्यूशन प्लान आता है, उसके अंदर जो है वो डेट जो होता है वो इट इज कन्वर्टेड इनटू इक्विटी, और उसके अंदर जो है वो अपने जो शेयर होल्डर्स होते हैं, जो कंपनी के जो होते हैं, शेयर होल्डिंग जो होते हैं वो कंपनी की, वो हमारे पास फाइनेंशियल एंटिटीज के पास आ जाते हैं, शेड्यूल कमर्शियल बैंक्स के पास आ जाती हैं एज पर द रिजोल्यूशन प्लान विच इज अप्रूव्ड और द रिस्ट्रक्चरिंग प्लान विच इज अप्रूव्ड। तो वो भी जो है वो जो फाइनेंशियल एंटिटीज है वो ठीक है, वो रिलेशन में तो आ गई, पर फिर भी जो है वो स्टिल दे आर एलिजिबल टू बी एज ए रिजोल्यूशन एप्लीकेंट, वो भी इसके अंदर आ सकते हैं, क्योंकि फाइनेंस जो है वो अल्टीमेटली बैंक्स ने देना है, या हमारे पास जो बाहर की जो कंपनीज आएंगी, एंटिटीज आएंगी जो कि फॉरेन सेंट्रल बैंक के साथ कंट्रोल करती हैं, वो देंगी, FIIs देंगी, तो वो भी जो है वो अगर इस तरीके से आती हैं तो वो भी एलिजिबल हो जाती हैं। इवन ARC है, ARC जो है वो भी हमारे को फाइनेंसिंग के लिए वो एलिजिबल होती है, और वो भी जो है कोई सी कंपनी के अंदर वो पार्टिसिपेट कर सकती है, द बेसिकली इन केस वेयर ही वांट्स टू हैव दैट। उसके बाद जो है अगर मान लीजिए कोई बाहर की कोई अल्टरनेट इन्वेस्टमेंट कंपनी है, फंड है, वो भी जो है वो रजिस्टर्ड है सेबी के साथ, वो भी जो है वो अपने आप को वो कर सकता है। तो इस तरीके से जो है वो ये बेसिकली इन नटशेल जो है वो ये है कि किस तरीके से जो पर्सन जो है वो इनएलिजिबल है और कौन से एलिजिबल हो सकते हैं, तो उसके लिए मैंने थोड़ा सा आपको एक्सप्लेन किया है। एनी क्वेश्चंस तो वी कैन से फॉर। थैंक यू वेरी मच।
Thank you, sir. Thanks a lot, sir. Just thinking, you have explained each and everything in a very lucid manner. So you have made the task of Nilesh ji very tough now, practically, because now he has to see to it that you have explained almost all the things. Now he has to explain how he will differentiate between his session and your session. That is the next thing which we need to see now.
Because I was not knowing how to go forward. You have straightly said that is I have to explain the.
मुझे लगता है मेरी आज की प्रेजेंटेशन लीक हो गई है, मुझे ये लग रहा है मेरे पास कुछ कहने के लिए बचा
नहीं, मैंने तो कोई कुछ भी नहीं बात किया सर।
नहीं, हमें आपसे बहुत कुछ सीखना है।
नहीं,
आप बहुत
राजीव जी has covered everything, but still I will make an attempt.
सेक्शन 29 है, जितनी बार पढ़ेंगे उतनी बार इसके अंदर नई न्यू थिंग्स आएंगी।
डेफिनेटली
ये तो सर छोटे-छोटे एक सब क्लास पे भी एक नए केस क्लास पूरे के पूरे बने हुए हैं। देयर इज थिंग्स टू बी डिस्कस प्रैक्टिकली।
ये तो एक ऐसा हमारे को फोरम मिला है कि जहाँ पे हम एक दूसरे के साथ और शेयर कर सकते हैं।
Yes,
to have a deep understanding about our subject.
Mamta ma'am, if you want to, you can say share something on it.
No, not at all. Let us just now.
Okay, fine.
The subject we really need to deep dive. Rajiv ji has set the tone.
Yes. So before we going for a detailed session on disqualification of PRAs, first of all, I will request Manoj ji to share latest development and issues of IPs. That is a very relevant for all of us practically. Even if we are not carrying on any type of the CIRP process, still this subject is very much relevant for all. Manoj ji, please.
Thank you, Ravi ji. Thank you very much. ये हमने एक जब हमने ये रेगुलर सेमिनार्स करने, वेबिनार्स जो सेमिनार्स करने शुरू करे, तो I carry forward my experience of my previous holding seminars or webinar, whereby I found कि अगर हम जब भी जो हमारी लास्ट मीटिंग हुई हो और उसके बाद जो अब प्रेजेंट वाली मीटिंग है, इसके बीच में क्या इंपॉर्टेंट डेवलपमेंट्स है जो हम आईपीएस के लिए रेलेवेंट है, तो दिस आई फाउंड इज वेरी इंटरेस्टिंग फॉर मोस्ट ऑफ द प्रैक्टिसिंग आईपीएस, बिकॉज होता है कि नो डाउट आजकल व्हाट्सएप की बड़ी फास्ट एज है, किसी जमाने में ईमेल बड़ा फास्ट होता था, बट वो अब लेकिन वो इजीनेस होने के चक्कर में ना वो इतने सारे व्हाट्सएप आपके पास आ जाते हैं, इतनी सारी ईमेल्स आ जाती हैं कि मेनी एडवांस यू मिस जो आप शायद मिस नहीं करना चाहते। इन आवर विजडम, इन द विजडम ऑफ आवर होल टीम, this is the collective effort of our whole IIPA team, me, Mamta ji, Dilesh ji, नवनीत जी एंड our little bit of staff जो हमारे पास है, हम सब लोग मिल के एक इस तरह से हम एक जॉइंट एफर्ट करके एक कलेक्टिव एफर्ट करके जो लेटेस्ट हैपनिंग है उनके साथ हम आपके साथ शेयर करना चाहेंगे. आई होप इट विल एनलाइटन ऑल ऑफ अस. और इसके साथ साथ अगर कोई अपनी कंट्रीब्यूशन भी करना चाहे, मे बी somebody has some other opinion also, he can also share with us. And without taking much time, मैं अपनी PowerPoint presentation start करता हूँ, please, with the permission of everybody. This is a very, very small introduction of mine.
Screen is not visible.
Because nothing is visible.
Sir, okay, I forgot to share. I just go back and do it. Sorry, I forgot to share the screen.
So now it is visible, sir. No. Yeah.
Yeah, it is coming. I think now it is absolutely visible and in a very proper manner.
Yes, sir. Yes, sir.
Yes, sir.
Yeah, my voice
Perfectly right.
is absolutely. In fact, I forgot to share the screen because I'm raising two, three things continuously. One is our live streaming on the YouTube. Another is background music. Third one is admitting all the people. And in that process, I forgot what I was mainly supposed to do. चलिए, this is our this is very small my introduction. This is introduction of our IIPA family. Traditionally we share it with everybody. We formed this association approximately 4.5 years ago. In fact, we were the first to form this association. We have around 70 members. We initially started with live membership, and within 2-3 months we were able to get many live members. After that we have stopped, but we are having a lot of queries and a lot of questions are being asked to us to open up the membership. That we shall be doing very soon. Our objective is to take care of IP's problem and their development. And we are running WhatsApp groups, Telegram groups, and we are holding physical meetings also. After Corona, not much there, but earlier we used to have. And our future roadmap is to expand horizontally and vertically at national level. We are existingly, our members are based on the national level, but we like to expand more, and we like to have all our branches and offices at all places where we have NCLT place, and headed by some person there. And last objective is that we want to make every IP as our member so that we can share knowledge with him. To this program, I'll be taking, I always say 15 minutes, but it always gets extended to half an hour. And the Nilesh Sharma ji, disqualification of PRA under Section 29A, law and due diligence by RPs. And after that, whatever questions we will be having from the audience or from Navneet ji, that will be answered by we panelists, consisting of me, Mamta ji, and Nilesh ji, and sir also. As far as latest developments is concerned, I come across 4 such developments. One, I'll be sharing some 8-10 judgments which happened during the last 1 month. I'll be sharing. I prepared my slide based on Schedule 3 and Schedule 3 analysis from IBC perspectives. Third aspect I have added there is a new FDs and updates for IPs. And fourth is that we are going to have a scheduled meeting on immediately after independence on Tuesday, 16th of August, with Honorable Chairman. And most probably this is the first time that he has given any association or any collective IPs to have a meeting with him, whereby we be sharing our concerns with them. since I must apologize for one thing, that since time is very short, in each judgment, I won't be reading the judgment in totality. I be reading only what crux of the judgment is there. जो एक इसके अंदर इशू था उसको कोर्ट ने किस तरह से सेटल करा है. I be mainly confining to that only. As if anybody is interested in going in detail for that particular judgment, so when we share our PPT with them, or when we share share our YouTube channel link with them, so मैं in sub judgments का I shall share the soft link also. In that case, that person can go there. I've chosen our last meeting held on 16th of July 2022. In fact, before that also we have a meeting on 9th of July 22. All the judgments are for the period starting from 9 July onwards till date. I've chosen my first judgment is that this is very important judgment as far as IP practitioners are concerned. This is in Sumit Kumar Gupta case, NCLT made some adverse observations for claim rejections by RP being unprofessional, which he got related without challenging the order. What happened in this case? NCLT made some observations on Sumit Kumar Gupta. plus some other things were there. As far as other things were concerned, he was not much bothered. But as far as the observations made against him was concerned, he was very much bothered. He filed appeal against the NCLT and got related those observations. Can anybody in the audience tell me why he did so? What benefit he has got? Because by this act, CD was not being benefited. Only he was being benefited. Can anybody share what was the reason or logic behind of getting it deleted? Because it was a very, very prudent step on his part, and we all IPs must follow this step also. Hanji Nilesh, bataiye sir, please.
Actually, I am not aware of, about the facts of this particular matters, but I think must have been for the reason that if suppose some adverse findings are there against an RP by an adjudicating authority, then definitely I think IBBI will be proceeding against him, will take some action against him because some adverse findings are there against him. Otherwise, the facts of this case I am not aware.
Absolutely. This is the only reason. Actually, facts in this case was that he rejected some claim, and the adverse party went to the court, and ultimately happened whatever happened there. And we IPs must learn from this thing there, because होता ये है इस केस के अंदर कि IBBI जब भी उनकी निगाह में ये ऐसी बात आती है, चाहे वो 6 महीने बाद, साल बाद, 2 साल बाद, 3 साल के बाद, they issue you a show cause notice, and as per their wisdom, they impose penalty on you. So is karke, if any adverse comment in any of the judgment is there, we must get it deleted for our safety. My next case is Vidarbha Industries case. Here, the Vidarbha Industries, this is Honorable Supreme Court judgment, 12 July 2022. WhatsApp पे मैंने काफी डिटेल में इसके बारे में लिखा था. What happened in this particular judgment was that, जब भी सेक्शन 7 की कोई एप्लीकेशन एडमिट होती थी, तो उसमें एनसीएलटी यही देखती थी एग्जिस्टेंस ऑफ डेट एंड सब्सिक्वेंट डिफॉल्ट, except that nothing was seen there. But Honorable Supreme Court, went deep into the section 7 and along with other sections also, and they came to the conclusion that if there is a genuine reason of default, then section 7 application should not be admitted. In fact, they reversed the NCLT order in this case. This is the very important judgment, because as far as admissibility of section 7 is concerned, this was in the days to come, it will have a very heavy effect and thought process on NCLT also, because अगर हम देखें तो हर जहां पे भी डिफॉल्ट होता है वहां पे कोई ना कोई रीजन तो होता ही है. अब वो उस रीजन की लेजिटिमेसी कितनी है, ऑनरेबल कोर्ट्स विल डिसाइड व्हाइल एडमिटिंग एप्लीकेशन 7. My third yes sir, Nilesh, you want to say something? Please carry on.
Yes. What I want to say here is that if this jurisdiction is given to the adjudicating authorities to go into all these details, I think litigations will improve, it will increase, and then disposal of the matter, I think, will not take place, because already we are seeing that in most of the matters, lot of time is being taken for admission of the applications which are filed. But if this jurisdiction, till now, this jurisdiction was not there with these with the adjudicating authorities or with different benches of NCLT. And only thing they were required to do was to see that if there is a default and whether that is more, the default is for more than 1 crore. So, but I think now the litigations will improve, and the admission of the case will be taking, I think, too much of time, because most of the cases now the corporate debtors will be taking this plea that for such and such reason I have become a defaulter, and this particular aspect should be considered while admitting my application.
यस सर, इन नटशेल नीरज जी का कहने का मतलब यह है कि वैसे ही एप्लीकेशन एडमिट नहीं होती, चाहे वो सेक्शन 7 की हो या सेक्शन 9 की हो। अब विद दिस पर्टिकुलर जजमेंट सेक्शन 7 की एप्लीकेशंस एडमिशन के अंदर और बहुत ज्यादा डिले होगा। और यू नो व्हाट दिस इज अफेक्टिंग, मैंने इसके ऊपर एक अच्छा सा आर्टिकल भी लिखा था, तो मेरे को बहुत सारे लोगों ने क्रिटिसाइज भी करा था। मैंने कहा ये एक पर्टिकुलर जजमेंट ऐसी है कि जो आने वाले टाइम में अगर आईबीसी भी पुराने वाले जो हमारे सिक्का लॉ थे या बाइफर आइफर के लॉज थे, ये उस लाइन पे ये आईबीसी को ले जाएगी। It's a very heartening, but we have to accept the wisdom of Honorable Supreme Court. उन्होंने अगर ये जजमेंट दी है तो कुछ ना कुछ सोच के दी है। इनफैक्ट आई हैव गोन टू द एक्सटेंट ऑफ सेइंग दिस थिंग कि पार्लियामेंट मस्ट कम आउट and take cognizance of this particular judgment and try to have some suitable amendment in the IBC, so that this sort of discretion may not be subject to abuse or may not be subject to delay in IBC, जो कि हमारा timeliness is the prime objective in IBC. चलिए सर, नेक्स्ट आगे चलते हैं। I found this is a very good judgment. This is a Tinkle Envirotech Private Limited versus ITO. ये ना NCLT की है, ना हाई कोर्ट की है, ना सुप्रीम कोर्ट की है, ये आई है इनकम टैक्स अपीलेट ट्रिब्यूनल से। मैंने इस जजमेंट को इस करके यानी कि अपने लिए ढूंढा, यानी कि हम सब लोगों ने ढूंढा, बिकॉज इट हैज समथिंग वेरी यूनिक सेइंग इन इट। व्हाट हैपेंड कि इन रूटीन केसेस के अंदर, जैसे टैक्सेशन के अंदर होता है, तो ये भी एक टैक्सेशन का कोई केस था। तो सीआईटी अपील ने, जैसे हमारे यहाँ पे फर्स्ट असेसिंग अथॉरिटी होता है इनकम टैक्स के अंदर, उसके बाद सेकंड सीआईडी अपील होता है, फिर उसके बाद आईटीएटी होता है, फिर आईटीएटी के बाद हाई कोर्ट है, देन सुप्रीम कोर्ट। तो सीआईडी अपील ने कुछ पॉइंट्स के ऊपर एसएससी को, कॉर्पोरेट डेटर को रिलीफ दे दिया। जिन पॉइंट्स पे रिलीफ दिया, उन पॉइंट्स पे डिपार्टमेंट जो था कॉर्पोरेट डेटर के अगेंस्ट चला गया ट्रिब्यूनल के अंदर, और जिन पॉइंट पे रिलीफ नहीं मिला था, उन पॉइंट्स पे जो था जो कॉर्पोरेट डेटर था, जो कंपनी थी, वो चलेगी आईटीएटी के अंदर। तो आईटीएटी जनरली यही करता है, जब भी इस तरह के दो सेम केस के लिए दो एप्लीकेशंस आती है, तो वो क्लब कर देता है। उन्होंने दोनों एप्लीकेशंस को क्लब करा, बट दे फाउंड समथिंग वेरी स्ट्रेंज इन इट। व्हाट हैपेंड कि इस कंपनी के अगेंस्ट मोरेटोरियम स्टार्ट हो गया था, सेक्शन 14 का ऑर्डर पास हो गया था, और जो F36 आता है, एक फॉर्म आता है जो हम क्या कहते हैं, ये फाइल करते हैं उसके लिए, यानी कि अपील के लिए। तो जो F36 फॉर्म था, डिपार्टमेंट का जो फॉर्म था, वो उन्होंने उस पे कुछ मेंशन नहीं था कि दिस कंपनी इज अंडर क्रिप। और जो एसएससी ने फॉर्म फाइल करा था, जो कंपनी ने फॉर्म फाइल करा था, वो उसने डायरेक्टर से साइन करवा के फाइल कर दिया था। तो आईटीटी ने ये करा, दोनों की दोनों अपीलों को रिजेक्ट कर दिया और कहा जी कि दिस इज बैड इन लॉ and nothing is going to, we're not going to hear it, and they dismissed both the appeals. Only relief they gave is that कि जब इनका क्रिप खत्म होगा, तब आप अपनी प्ली लेके आना, या आप इसके अगेंस्ट में सीरियस एप्लीकेशन फाइल करिए। तो why have they chosen this judgment? Only for the reason is that कि हम जब भी कोई सेक्शन 14 के ऑर्डर के बाद कोई भी अपील फाइल करें, कुछ भी करें, तो इट शुड बी डन बाय द IRP और RP और लिक्विडेटर एज द केस मे बी।
Correct. Correct. Yes.
Yeah. My fourth judgment which I've chosen is that the Kotak Mahindra Bank versus New Persistent Parts Private Limited, ये भी ऑनरेबल सुप्रीम कोर्ट की जजमेंट है, ये भी हार्डली 5 अगस्त को ही आई है। इस केस के अंदर एनसीएलटी ने हेल्ड करा कि प्रिजन ऑफ सेक्शन 7 सबसेक्शन 5 सबसेक्शन बी ऑफ द कोड पर इंटीमेशन टू द फाइनेंशियल क्रेडिटर बिफोर रिजेक्शन ऑफ हिज क्लेम is mandatory in a nature. A lot of other issues are also discussed there. I'm not delving that into it. IBBI ने इस जजमेंट को काफी डिटेल में सब आईपीएस को दिया था। तो मेन इसके अंदर ये था कि व्हेन वी आईपीएस आर वर्किंग, तो नो दिस इज अ सेटल्ड नो कि अगर हम किसी का भी क्लेम रिड्यूस करते हैं या रिजेक्ट करते हैं, इट हैज द अदर पर्सन हैज टू बी गिवन एन अपॉर्चुनिटी ऑफ बीइंग हर्ड, अदरवाइज वी आर रिस्पॉन्सिबल, और हमारा जो क्या कहते हैं, जो हमारा काम होगा वो एक्सेप्टेबल नहीं होगा कोर्ट को। My fifth judgment is of Kushal Limited versus Karthik Baldwa. इसके अंदर what understanding of the law is that कि इसके अंदर NCLT ने ये held करा है कि an important question of law they have held that can NCLT recall its order or not, मीनिंग देयर बाय कि अगर NCLT ने कोई एक चीज को ऑर्डर कर दिया और उसके बाद किसी भी कारण से उनको लगा कि ये ऑर्डर को हम change करना चाहते हैं, in technically want to recall it, can they recall it or not? What my understanding of law was that in fact it happened in one of my case also. The Intech, I remember Intech something case was there. So NCLT refused that we can't recall the our order once we have issued it. But NCLT has held in this case that NCLT in case of any reason, any naturally the specified reason, they can recall their order. Another judgment I have looked into is that a Rajiv Srivastava case RP. In this case, what happened that RP resigned, and the question rose who will look after the company. His resignation was accepted by the court also, and there were 2 or 3 thoughts. One thought was that till the appointment of the next RP, let this RP continue. And the one thought was that there, but NCLT held otherwise. They said once RP resigned, he has no right to continue. He can't hold any of the COC. They just to get rid of routine business, they court appointed their own officer, and they said that till the appointment of next RP, you take care of all the CIP proceedings of the CD. Next, I have chosen is of S. Chandira versus Sunil Kumar Agarwal. Here, question of debt under Section 5, Subsection 8 has been answered. What happened that in this particular case, applicant paid some money for the purchase of land from the CD. When they paid that particular advance money, and he said, since it might have been written in the clause as usually, which is written in the agreement to sell, कि अगर आप डील नहीं करोगे तो हम डबल पैसे आपको वापस करेंगे या समथिंग लाइक दैट करके करेंगे. तो a question and law arose कि whether it will be a financial debt or not, whether it is covered under Section 5 Subsection 8 or not. Honorable NCLT honored in a negative manner. They said the essence of any financial debt is that there should be a time value of money. Since there is no time value of money, it is a contractual obligation. हमारे को डबल पैसे दोगे या वो करोगे, we don't agree with it. It is not a time value of money. It is a contractual thing. Hence, they said that your debt is not an what you call it, financial debt. It is the other debt, and your claim priority as per Section 53 will be given to you accordingly. Another judgment which I have chosen is that of Jitendra Kumar Singh. In this case, another issue was being settled. It generally happens that in the case of Section 9 application, जब भी ऑपरेशनल कैरेक्टर कोई भी एप्लीकेशन इस तरह से देता है तो हमारे को मैंडेटरली सेक्शन 8 का नोटिस देना पड़ता है. जब भी हम सेक्शन 8 का नोटिस देते हैं तो उसके अंदर ये नोटिस डिलीवरी का एक मैनी टाइम बहुत बड़ा इशू आता है. तो ये जो नोटिस था ये डिलीवर करा गया था कंसर्न्ड डायरेक्टर को. So he took a plea that this notice has not been served on the CD, and hence all the proceedings under Section 9 proposed to be 9 application should not be admitted. NCLT had, the NCLT held otherwise. They said the notice received by the director is as good as delivered to the CD, and admission order was held to be good in law. लास्ट मेरी जजमेंट है नेशनल कंपनी ट्रिब्यूनल बार एसोसिएशन वर्सेस यूनियन ऑफ इंडिया. ये भी एक तरीका हुई है. इट इज नॉट मच रेलेवेंट टू अस, बट एकेडमिकली इट इज विच लिटिल बिट ऑफ रेलेवेंट टू अस. इस केस में क्या हुआ था कि व्हाट हैपेंड कि एनसीएलटी ने कुछ अपॉइंटमेंट्स करी थी आज से 3-3.5 साल पहले, जिसके अंदर उन्होंने 23 मेंबर्स को ऑल ओवर इंडिया बेसिस पे अपॉइंट करा था. तो उसमें व्हाट हैपेंड कि 8 मेंबर्स को तो उनका टेन्योर उन्होंने बढ़ा दिया. 3 इनिशियल अपॉइंटमेंट 3 साल की थी, बाकी का टेन्योर उन्होंने ऑन द बेसिस ऑफ द रिपोर्ट ऑफ द प्रिंसिपल बेंच टेन्योर नहीं बढ़ाया. बार चलेगी क्या कहते हैं सुप्रीम कोर्ट के अंदर दैट इट इज अ वायलेशन ऑफ सेक्शन 413 ऑफ कंपनीज एक्ट। तो जिनका आपने टेनर नहीं बढ़ाया उनको भी आगे कंटिन्यू करिए। दे गिव लॉट ऑफ प्लीज की आईबीसी ये है वो है डिले है ये होता है दाएं बाएं। ऑनरेबल सुप्रीम कोर्ट सेड नो, कहता है कि बार इज नॉट ए राइटफुल पर्सन टू डिसाइड कि किसको एनसीएलटी का जज बनाना है या किसको नहीं बनाना। what decision government or we have taken, that is right, and they did not allow extension of balance 15 NCLT members. They said अभी जैसे आप सब लोगों को पता भी होगा 12 लास्ट वीक थी जब NCLT की एप्लीकेशन मांगी थी। they said कि आप इसके अंदर अप्लाई कर लीजिए and visually you may be get appointed. ओके जैसे कि हम लोग चार्टर्ड अकाउंटेंट्स हैं, हम लोग शेड्यूल 3 में काफी सारा काम करते हैं और बैलेंस शीट्स बना रहे थे। हमारा ऑफिस ही बैलेंस शीट बना रहा था। although I'm much involved in IBC, but still I need to supervise my audit and other functions also. तो everybody knows कि शेड्यूल 3 जो है वो चेंज हो गया है। जब वो शेड्यूल 3 चेंज हो गया है तो जो शेड्यूल 3 चेंज हुआ है इस बारी, can anybody tell me, schedule 3 for the preparation of balance sheet is under Companies Act 2013. 1956 में जो शेड्यूल था उसका क्या नंबर था? I think every old person
14.
be knowing it very well.
14, I think.
6.
No.
Six.
Yes.
Correct,
Company Act है ना मैम, she knows better than us. सर आप सीए की प्रैक्टिस कम करते हो, आईबीसी की ज्यादा करते हो। In any case, it's just for the sake of fun only. तो शेड्यूल 6 था। तो शेड्यूल 6 को जब 2013 आया तो उन्होंने शेड्यूल 3 के अंदर करा गया। जब ये शेड्यूल 3 की मेजर अमेंडमेंट्स जो आई हैं, ये शायद ये आ तो 2000 में गई थी, लेकिन कोरोना के चक्कर में इसको हर साल 2010 में आ गई थी, लेकिन कोरोना के चक्कर में इनको हर साल पोस्टपोन किया जा रहा था। और 9 इस बारी जो है आई एम सॉरी 2020 में आ गई थी, तो लेकिन कोरोना के चक्कर में इसको पोस्टपोन किया जा रहा था। अब ये फाइनेंशियल ईयर 21-22 ये पहली बारी होगा जब इस शेड्यूल 3 के अंदर ये कुछ ये हमारे को नई बैलेंस शीट बनानी पड़ेगी। शेड्यूल 3 यू सी द माइट ऑफ आवर आईबीसी। शेड्यूल 3 को जो इस बार उन्होंने चेंज करा है, इसके अंदर बहुत सारे चेंजेस वो ऐसे लाए हैं जो कि सिर्फ बिकॉज ऑफ द रिक्वायरमेंट ऑफ द आईबीसी ओनली। आई एनालाइज कि व्हाट आर दोस रीजंस कि जो इन माय ओपिनियन एज एन आईपी वी शुड नो, और इट हैज बीन ब्रॉट विद द पर्सपेक्टिव ऑफ आईबीसी ओनली। तो ये है जी सबसे पहला जो चेंज इसके अंदर मेरे को मिला वो ये है ट्रेड पेबल्स। ट्रेड पेबल जो था इसकी पहले कोई क्लासिफिकेशन नहीं थी, सिर्फ हमारे को ये देना पड़ता था। अब इसको 20 टाइप्स में इसको हमारे को एक बैलेंस शीट के अंदर क्लासिफाई करके देना है। I've written the para 6 FB के अंदर भी है less than 1 year, 1 to 2 year, 2 to 3 year, more than 3 years, and MSME other disputed और others। अब देखिए अब इसके अंदर हमारे को प्लानिंग क्या करनी है। ये तो सबको पता है, जो भी लोग बैलेंस शीट बनाने दे आर ऑल अवेयर ऑफ इट। व्हाट प्लानिंग वी हैव टू डू। ट्रेड पेबल मीन कि हमारा जिसको हमने पैसे देने हैं इन द नॉर्मल कोर्स ऑफ बिजनेस फॉर बाइंग गुड्स और सर्विसेज। मेनी टाइम्स इट हैपेंस कि यू आर अवेयर ऑफ इट कि ये पार्टी के किसी भी फाइनेंशियल कंटीजेंसी करके या किसी भी और कारण से आप इसके पैसे नहीं दे पा रहे, एंड दिस पर्सन इज गोइंग टू फाइल एन एप्लीकेशन अंडर सेक्शन 9 अगेंस्ट यू। तो आप इसके लिए प्लानिंग कर सकते हैं। कैसे प्लानिंग कर सकते हैं? जो नीचे वाले 3 कॉलम है, 3 या चौथा कॉलम है कि ट्राई टू पुट हिज ड्यूज इन दिस डिस्प्यूटेड ड्यूज। द मोमेंट यू पुट दिस थिंग इन दिस डिस्प्यूटेड ड्यूज, तो he will have देखिए ऑडिटेड जो स्टेटमेंट्स होती है ना, इनको कोर्ट बहुत अच्छी तरह से और बहुत अथेंटिकली मानता है। आई रिमेम्बर इन वन ऑफ माई केस हम लोगों ने एक एप्लीकेशन डाली हुई थी, तो बैलेंस शीट के अंदर ना जितनी हमने सेक्शन 7 की एप्लीकेशन डाली हुई थी, प्रीवियस ईयर और करंट ईयर में उतना ही फर्क आ रहा था। तो ऑनरेबल कोर्ट इमीडिएटली सेड हाँ आपने ये पैसे दिए होंगे, तभी तो फिगर्स के अंदर फर्क आ रहा है। तो व्हाट आई मीन टू से इज दैट कि अगर आपके किसी क्लाइंट का या किसी और का इस तरह से कुछ है, तो आप उसको किसी भी तरह से अपने ऑडिटर से सर्टिफाई करवा लीजिए अगेंस्ट डिस्प्यूटेड ड्यूज। यू मे हैव वन स्केपगॉट। दूसरा मैंने ये देखा है ये ट्रेड रिसीवेबल्स में। ट्रेड रिसीवेबल्स के अंदर भी सेम कहानी। ट्रेड रिसीवेबल का मतलब भी हमने जिससे पैसे लेने हैं, अगर हमने कोई ऐसी प्लानिंग करी है जिसके अंदर हमने आने वाले टाइम में सेक्शन 9 की एप्लीकेशन उसके अगेंस्ट डालनी है, तो बिफोर पुटिंग दैट एप्लीकेशन, मेक श्योर दैट इन योर ऑडिटेड बैलेंस शीट इट इज नॉट शोन अंडर कॉलम 3 and 4 disputed or trade receivables considered good or considered doubtful. और तीसरी एक और बात है कि लिमिटेशन इज आल्सो वेरी इंपॉर्टेंट इन आवर केस, एंड मेक श्योर that this particular debt is not shown under the column more than 3 years old. Another thing I found is that which has been additional requirement on Schedule 3, a company shall disclose shareholding of promoters. Many a times ऐसा होता है कि जैसे छोटे केसेस के अंदर बहुत बारी होता है, हमारे को पता नहीं चलता कि इसका रियल ओनर कौन है. Many a times you find only employees, otherwise persons there. No, in Schedule 3 compulsorily auditor has to disclose who is the promoter. So this can also give us a good clue. Now as per para 6/3, हमारे को लोन्स एडवांसेस जो हमने प्रमोटर्स को दिए हैं, डायरेक्टर्स को दिए हैं, की मैनेजमेंट पर्सन को दिया और उनके रिलेटेड पार्टीज को दिए हैं, जो हमारी पफ की जो हमारी क्या कहते हैं एप्लीकेशन जाती है ना, प्रोफेशनल अंडरवैल्यूड फ्रॉडुलेंट एग्जॉस्टेड ट्रांजैक्शन स्कीम, तो ये जो डिटेल हमारे को आने वाले टाइम में मिलेगी, दैट कैन हेल्प अस. पांचवा हमारा पॉइंट ये है कि मेनी टाइम्स वी सी कि कंपनी के बैलेंस शीट के अंदर एसेट्स तो आ रहे होते हैं और क्या कहते हैं जब टाइटल डीड लेने जाओ तो वो देखो उनका, तो वो टाइटल होता है in the name of promoters or directors or like that. अब government in their wisdom after seeing such cases in IBC, I remember ये most of the इनके दो एग्जांपल्स मेरे को लाइव अपनी प्रैक्टिकल लाइफ के अंदर याद आ रहे हैं कि एक तो जितने भी ये many not all but most of the home buyers केस के अंदर जो लैंड होती है वो जनरली प्रमोटर अपने नाम पे ले लेता है और कंस्ट्रक्शन एंड एवरीथिंग इज पुट इन द नेम ऑफ द सिटी. नंबर 1. नंबर 2, मैंने ये देखा कि कार्स वगैरह मेनी टाइम्स होती है, कुछ स्कीम्स होती हैं जब पर्सनल पे जो इंडिविजुअल्स को उसके अगेंस्ट लो रेट ऑफ इंटरेस्ट मिल जाता है, दे डू टेक इन देयर नेम बट एवरी ऑल इंस्टॉलमेंट इंटरेस्ट एंड अदर एक्सपेंसेस आर बीइंग क्लेम्ड इन द सीडी. तो नो, अर्लियर देयर वाज नो डिस्क्लोजर, कुछ इसका डिस्क्लोजर नहीं था एज एन ऑडिटर. नाउ दे हैव मेड इट कंपल्सरी कि हमारे को इसका डिस्क्लोजर करना पड़ेगा. जो भी हमारी टाइटल डीड्स हैं प्रॉपर्टीज की हैं, या जो भी पीपीई कहते हैं हम इसको, प्लांट एंड द इंटेंजिबल एसेट्स, तो उसकी डिटेल देनी पड़ेगी. अगर कोई भी कंपनी का नाम पे नहीं है तो वी हैव टू गिव रीजंस फॉर दैट आल्सो. यस, अब ममता जी विल एग्री विद मी कि हम जितने भी क्रिप्ट के केसेस करते हैं इनमें कुछ और मिले या ना मिले, लेकिन स्टॉक तो कभी नहीं मिलता. आई थिंक एवरीबॉडी विल अप्रिशिएट, नीलेश जी भी अप्रिशिएट करेंगे, जब बाकी भी अप्रिशिएट करेंगे कि यानी कि अब जब भी किसी भी कंपनी का जैसे ही आप उसके एसेट्स टेक ओवर करते हो, स्टॉक तो रेयरली मिलता है आपको, और स्पेशली जो मूवेबल स्टॉक होता है कभी नहीं मिलता. फिक्स्ड एसेट तो फिल्म मिल जाते हैं, स्टॉक कभी नहीं मिलता. स्टॉक करंट एसेट इंक्लूड स्टॉक आल्सो एंड डेट्स आल्सो. तो और नाउ इन केस ऑफ जब 5 करोड़ से ऊपर की बोरिंग है तो ये आरबीआई की गाइडलाइंस हैं कि आपको उसकी क्वार्टरली स्टेटमेंट ऑडिटेड भेजनी पड़ती है बैंकर के पास, कि सर्टिफाइंग दिस थिंग कि ये इसकी स्टॉक है, ये इस तरह से है. और पहले तो भेजनी पड़ती थी, भेजी तो पहले भी जाती थी, बट डिस्पाइट ऑल दिस थिंग ये हम आप लोग सब लोग जानते हैं कि स्टेटमेंट कैसे दी जाती थी. नो, another responsibility has put on the statutory auditor, he has to reconcile कि जो स्टेटमेंट वहां पे भेजी गई है और जो बुक्स के अंदर वो क्या कहते हैं स्टॉक की फिगर्स आ रही हैं वो रिकनसाइल करती है या नहीं है, यानी कि बिल्कुल ठीक होनी चाहिए, जो भेजी है वही होनी चाहिए, और अगर उसके बीच में कोई डिफरेंस है तो इट शुड बी रिकनसाइल्ड. इनफैक्ट आई वाज एनालाइजिंग सम लिस्टेड कंपनीज बैलेंस शीट्स आल्सो जो ऑलरेडी पब्लिश हो गई है, तो उन्हें मैंने देखा था कि ऑल द डिटेल्स आर पुट रिकंसिलेशन देयर. तो व्हाट आई मीन टू से दैट कि आईबीसी में हमारे पास अगर ड्यूरिंग द ईयर कोई केस होता है तो पहले हम देखते थे कि लास्ट 31 मार्च का क्या है, बट नाउ दिस फिगर कैन हेल्प अस टू नो कि स्टॉक की पोजीशन लेटेस्ट क्वार्टर की क्या है. जेस्टेशन ऑफ चार्जेस और सेटिस्फैक्शन विद रजिस्टर ऑफ कंपनीज. रजिस्ट्रेशन तो हमेशा होता है, बट whenever loan is due but satisfaction नहीं होता. तो now statutory auditor has been made responsible that he should give detail of after verifying from the portal कि ये क्या है. So this is also something very good on our IBC part. Or compliance with number of layers of companies. You know, in our Companies Act, we are permitted to have, if A is a holding company, it can have one subsidiary S1, then S1 can have another subsidiary S2. After 2 layers, we are not allowed permitted. But practically many a times we have seen that there are many layers therein. And a statutory auditor also, without qualifying or their report, they are, signing a balance sheet and this thing there. No, it has been made compulsory on them to look into that if there are any, more layers on the more than 2 layers are there or not. If there are more than 2 layers, it's absolutely violation of Companies Act and it is not allowable. Why I'm saying how this is, good for the IBC angle is that कि now we can understand कि promoters की कहाँ पे किस लेवल तक वो उनकी वो क्या कहते हैं होल्डिंग्स है. वेरियस रेशियोज अच्छी कंपनी के लिए तो अगर हम एनालाइज करने की कोशिश करें तो रेशियोज कैन गिव अस अ वेरी गुड इंडिकेशन कि ये कंपनी आईबीसी में क्यों है. ओनली थिंग इज वी नीड टू एनालाइज इट. और स्पेशली हम लोगों को डिटेल्स को ये कहा गया कि वेयर देयर इज एनी डिफरेंस ऑफ 25% from the previous year, you need to give the reasons for that also. Those reasons, shall be very helpful. We IBC people. ये ममता जी कभी कभार फायदा हो जाता है जब आप ऑडिट भी करते हो और आईबीसी भी करते हो तो दोनों को क्लब कर लेते हो.
True. Manoj ji, now it may so happen that this will fall under the RP term. तो पिछले साल का CRP में चला गया. RP will have a lot of difficulty to collate all this data. But anyways, it's very useful.
That will be a. But अगर what I feel is that कि जितने भी क्रिप केसेस आपने भी हैंडल करे हैं मैंने भी करे हैं थोड़ी सी डाटा तो होता है कहीं ना कहीं. ओनली थिंग इज कि थोड़ी सी एक्स्ट्रा मेहनत करनी पड़ जाती है उस चीजों को बनाने के लिए. दैट इज ट्रू. हाँ बिल्कुल ठीक कहा आपने. Okay, these were my only case laws and this thing there. अब ये कुछ थोड़े से न्यू एवेन्यूज आए हैं हम आईपीएस के लिए, उनके बारे में लिटिल बिट अपडेट देना चाहूंगा. इनफैक्ट पीएनबी ने जो था एम्पैनलमेंट एज फार एज माय नॉलेज वाज कंसर्न अगस्त के अंदर उन्होंने खोल देनी थी नई एम्पैनलमेंट. दे ऑलरेडी ओपनड अप बट नाउ दे वर टेकिंग सम अदर new IPs also for their empanelment, but they sent the file to the higher management also, but higher management refused. उन्होंने कहा कि पिछली empanelment को अभी 1 साल तो बीत जाने दो उसके बाद हम करेंगे. तो most probably it will come up again in the month of October. So all IPs if they want to get empanelment of PNB, because SBI के बाद आज के डेट में PNB ही बड़ा बैंक आता है, तो please take care of it. In this parliament session अगर जो गुत्थम गुत्थी ज्यादा नहीं होती तो हमारी ये आईबीसी अमेंडमेंट्स का जो था ये भी पास हो जाना था. अब इसके अंदर क्या क्या एसेंशियल फीचर्स है आई जस्ट एनलाइटन माय फ्रेंड्स कलीग्स कि इसके अंदर जो हम अभी नीलेश जी बात कर रहे थे कि डिफॉल्ट की और टाइम बढ़ जाएगा, तो दे गवर्नमेंट इज आल्सो अवेयर ऑफ दिस थिंग. दे वांट टू ब्रिंग एन अमेंडमेंट. आई एम नॉट अवेयर ऑफ द अमेंडमेंट व्हाट अमेंडमेंट्स आर देयर, बट दे आर ब्रिंगिंग अमेंडमेंट वेयर बाय default shall be established quickly. For example, जो डिस्कशन पेपर आया था तो उसमें उन्होंने कहा था कि in case of section 9 एप्लीकेशन आप अपनी जीएसटी के रिटर्न्स दो, lot of other things were there. हो सकता है उस तरह का कुछ अमेंडमेंट लॉ के अंदर है. तीसरा था कि गवर्नमेंट हैव आल्सो रियलाइज कि जितनी भी पफ की ये ट्रांसैक्शन के जितना भी ये बैंक लोन की अमाउंट निकलता है ये रिकवरी इसकी बड़ी नेग्लिजिबल है या ना के बराबर है. तो इसके लिए भी they want to bring some changes in the law. Third is that they want to control COC also. For them they are also bringing the code. Discussion पेपर ऑलरेडी आ गया था और एक सेपरेट चैप्टर जैसे PR IIPP का हुआ था ये क्रॉस बॉर्डर का भी एक चैप्टर इसके अंदर आएगा. Thank you very much. I hope I've been able to enlighten everybody there. और अगर मेरी बातों से कोई बोर हुआ तो I'm really sorry for that. नीलेश जी का शायद मैंने टाइम थोड़ा सा ज्यादा ले लिया. So Nilesh ji, I hope you be enlightened with my presentation, and in fact, I am also enlightened with your sayings.
मनोज जी, आपकी प्रेजेंटेशन हमने एक बड़ी अच्छी कहावत सुनी है, गागर में सागर. एंड प्रैक्टिकली आई मस्ट से आपकी जो प्रेजेंटेशन थी उसने सब कुछ हमें जो हमारे लिए रेलेवेंट है सारी की सारी चीजें आप लेके आए. थैंक्स अ लॉट फॉर दैट. मेरे ख्याल सारे मेंबर्स को इन चीजों से काफी ज्यादा फायदा ही मिलेगा, दैट आई कैन से फॉर श्योर. एंड I think now it's the time, Nilesh ji. So I'll request you to please take over and आप अपनी presentation शुरू करिए क्योंकि members बहुत देर से इस चीज का भी wait कर रहे हैं.
Sure.
Over to you, Nilesh ji.
थैंक यू वेरी मच नवनीत जी और मनोज जी, बहुत अच्छा आपने इंफॉर्मेटिव ये जो आपका प्रेजेंटेशन रहा और उससे पहले राजीव खुराना जी ने भी हमको एनलाइटन किया अबाउट द प्रोविजंस ऑफ 29A. So I'm not left with anything new to say, but still I have made one presentation and I will try that. I think again we go through these provisions and I think we will definitely be benefited by this. So I am having a presentation which I will PPT which I will share. I think you have to allow me, Manoj ji, to share my PPT. मनोज जी मुझे अलाउ कर दीजिए.
हाँ, मैंने को होस्ट आप थोड़ा सा लेट आए थे. यस, एक मिनट जी रुकिए, मैं आपको कोर्स बाकी सबको तो मैंने बना दिया था आपको. हाँ
सर एलो कर दिया सर. नीलेश जी एलो
ओके
आप कर लीजिए.
ओके जी, थैंक यू. वन मिनट प्लीज, 1 मिनट.
सर कर दिया अलाउ आपको.
हाँ थैंक्स. I hope you are able to look at this particular.
Yes, it's visible.
PPT.
Visible, sir. Visible. Your PPT is visible.
Okay, 1 minute, please. Yes. So section 29A, law and the provisions of law and the due diligence which is required to be done by the resolution professional while they are conducting CIRP process. So this is the topic of this particular PPT. Genesis and background. So you are aware that section 29A was not there initially, and subsequently only by way of an ordinance in 2017, these particular provisions were inserted into the IBC code. And you are aware the background or the reason was that dirty 12 accounts. You know that dirty 12 accounts or big 12 IBC matters, where the debt amount was debt to banks and financial institutions was approximately 250,000 crores. So these were the matters which were referred to IBC. And then it was realized by the government of India that what will happen in these particular matters after this CIRP process is over. So they realized that what will happen is that in place of 2 lakh presently, or at that particular point of time, their debt level was 250,000 crore. And after approval of resolution plan, the debt will be reduced to maybe less than 1 lakh crore, and the same individuals will be there as the promoters. So I think it would have been a big political issue to counter that. The provisions of 29A were inserted. And the intention was that undesirable persons, the persons who were responsible for bringing the companies to the corporate debtors to insolvency situation, they should not be allowed to participate in the resolution process. They should not be allowed to again acquire these companies. Okay, so initially by way of this ordinance, these provisions were inserted, and subsequently the Insolvency and Bankruptcy Code Amendment Act was there, which came into force with effect from 6 June 2018. However, these provisions were given retrospective effect from 23rd 11/2017. So what have been the impact of this? Impact of this section 29A insertion has been that the person who wants to give a resolution plan, he must fulfill the criteria which is decided by the COC under section 25(2)(h), and then at the same time he has to see that he does not fall within the ambit of section 29A. So these are the two sections which prescribe or which provide that who are the persons who can participate in the resolution process of a corporate debtor. Now let's see what these provisions are. So section 29A starts with the words, a person shall not be eligible to submit a resolution plan if such person or any other person acting jointly or in concert with such person. So these disqualifications are applicable not only to the person who proposes to file that resolution plan, but all those persons who are jointly along with him, they propose to acquire a particular company. Okay, so it's further interpretation. We are having that judgment of Honorable Supreme Court. We will determine as to whether these provisions are applicable to that particular person who intends to file a resolution plan, or to his relatives also, his wife, his brother, or any other relative who falls within the ambit of section 524 and 524A. So that, I think that is the question all of us are having in our mind as to whether all of them, they become disqualified. So I'm having answer to that, and that is that answer has been provided by Honorable Supreme Court in a judgment, which is part of my presentation. So let's start as to very quickly, though Mr. Khurana has already briefed us about all this, but very quickly we go through all this. An undischarged insolvent. So this person and the persons acting in concern, they should not be undischarged insolvent. But this word has not been defined. Undischarged insolvent word, I have not seen any definition under IBC or under any other Companies Act or at any other place or in under regulations also. Though section 79, I think subsection 3 defines the word bankrupt. And within the definition of bankrupt, it says that it includes any person adjudged as an undischarged insolvent. But nowhere it is mentioned under law as to how a person becomes an undischarged insolvent. So the word, as I said, bankrupt is defined under the Act. Then undischarged bankrupt is also defined under that. Okay, and during the insolvency, so one interpretation can be a person who is undergoing insolvency process is undischarged insolvent. But I have not seen any disqualification which have been applied by law to undischarged insolvents. All the disqualifications which are there, those have been applied to undischarged bankrupt. And undischarged bankrupt is defined as the person who has been against whom the order has been passed for initiation of or admission of bankruptcy process, and then under section 126 of IBC, until the time a discharge order is passed against him under section 138 of IBC. So during that period, during the period when bankruptcy process is going on against an individual, he remains as undischarged bankrupt. And during this period only certain disqualifications are there. But after that, after he is declared as, after he is discharged as bankrupt, then he is not having any disqualification. So my interpretation is that I think this here, the word is an undischarged insolvent mean an undischarged bankrupt. However, I think this is required to be clarified by making a change under the law. Second is a person who is a willful defaulter as per the guidelines of Reserve Bank of India. So you are aware that RBI has issued the guidelines as per which bankers, they have to consider whether a particular defaulter becomes a willful defaulter. And the definition mainly the clauses are that one, that that particular defaulter or that particular borrower is having the capacity to pay and is not making payment. This is one. Second is that he has diverted money, he has siphoned away money, he has taken money out of the company. Third is that he has utilized the money for the purpose other than for which it was disbursed to him. So there also, so these are the three instances, and then there are other also, like you are not operating your bank account with your financing bankers. You are operating your bank account with a bank which is not your lender bank, and which is not as per the permission of your lender bank. Then also you can be declared as a willful defaulter. So now we are not supposed to go into the definition. However, we have to see that whether he has been declared as a willful defaulter. But our problem is that we can't access, we are not having access to all those lists. But we have to see that these different bankers, we have to, they are maintaining these lists, and we can attempt to see that their names are not included in those defaulters list. In addition, we obtained this one affidavit also from that. So I'm having a separate slides as to how to determine, how to verify that a person is an undischarged insolvent or a willful defaulter, or what due diligence is required to be done by the resolution professional. So now section 29AC. So 29AC, it says that if a person is having an account, so this particular person is having an NPA account, or a corporate debtor under his management or control, or of the corporate debtor, he's the promoter. Okay, so either himself, he's having this kind of account which is NPA, or any company, any corporate debtor under his management or control, or CD who he is a promoter of the CD. So if any of these accounts are classified as NPA by RBI, so it is not by RBI, actually it is by the pursuant to the guidelines issued by RBI, and bankers, particular lenders, they have to declare an account as NPA. And at least 1 year has elapsed from the date of such classification till the date of insolvency commencement date. So the 1 year time period should have passed. Why this 1 year? 1 year. So I think assumption here is that if a person does not settle his liability or does not regularize his account within a period of 1 year after it has become NPA, then he is disqualified. Okay, so as on the date of ICD, more than 1 year should not have passed. But
may I interrupt, sir?
Yes.
Basically,
yes,
for this reason, it is the NPA classification. Up to 12 months, it is the account is treated as substandard, and after 1 year, it is treated as doubtful, and then the loss.
Correct.
So, because,
correct.
So it is a soft corner. It is that the substandard accounts have been taken into this.
Yeah. So that if they want, they can regularize or they settle.
Yes,
if they don't, then they should be treated as disqualified.
Yes.
Thank you, Rajiv ji. But this disqualification will not apply if the said person has made payments of all overdue amounts with interest before submission of resolution plan. So which was done in the matter of SR Steel Limited. I think ArcelorMittal, they paid the defaulted amount in cases where the accounts had become NPAs, and then they became qualified for submission of resolution plan. Then this particular clause does not apply to a resolution applicant who is a financial entity. So financial entity, but there is another condition, and which is that it should not be a related party to the CD. And financial entities are also defined under IBC, under this section 29A only. So what is the meaning of this? That if suppose a bank is otherwise disqualified, is falling under this one, or an NBFC is falling under section 29AC, so then it is not disqualified. But only when it is related to when it is a related party to the CD, then only it is disqualified. Okay, so all these disqualifications, so it is not that they must be related to this particular corporate debtor only. like in 29 AC, if you are having any other company, not only debtor, corporate debtor, some other company in the group which has become a defaulter, even then you are disqualified to file a resolution plan in the case of a particular corporate debtor. Okay, so but here they say that if you are if a financial entity is related party of the CD, then this disqualification will apply to you. But if you are becoming disqualified because you are having some other, you are not related to the CD, then this disqualification will not apply to you. Then there is another exception here, which says that financial entity, which is a related party of the CD, on account of conversion or substitution of the debt into equity prior to ICD, is not to be treated as a related party. So you are aware that in most of the loan agreements also, and then I think there used to be one scheme also of Reserve Bank of India where bankers were allowed to convert their part of their debt into equity, and they were getting the control over 51% of the equity of the defaulting company. So if you have acquired the equity pursuant to the same by conversion of your debt into equity, or suppose you are holding some debentures which are converted into equity. So if you have become a related entity of the CD on account of this, then you are not disqualified. Okay, provided this conversion has taken place prior to the ICD. Then if such an account was acquired, there is another exception. Suppose if I am a resolution applicant, I acquire some company, and then company's account is NPA for more than 1 year, and then you are proposing, or I am proposing in the resolution plan that I will be making payment over a period of 3 years or 4 years, and that plan is approved. So in that case also, I will not be treated as, if I have acquired this company and account is NPA, then for a period of 3 years from the date of approval of plan by adjudicating authority under IBC, this particular clause 29 AC will not apply for a period of 3 years. So if you have acquired a company through a resolution process where resolution plan is approved by the adjudicating authority under IBC, then for a period of 3 years, even if you are having an NPA account, you are not disqualified here. Then 29 AD, as Rajiv ji have explained, that if under any law which is, or under any act which is listed in 12th schedule of IBC, and then as per under that act you are convicted for a period of 2 years or more, then you are disqualified. In any other law you are convicted for a period of 7 years or more, then also you are disqualified. So here conviction, the word is conviction. It is not that some charge sheet is filed against you. So unless conviction order is passed, you will not be treated as disqualified. And then if suppose there is a conviction order, and then in the higher court or the appellate court has stayed your conviction, even then also you will not be treated as disqualified because there is a stay on that particular order. And then there is another exception which Rajiv ji told us, that for a period of, I think after you have, for a period of 2 years, after you have completed your punishment or imprisonment, after that, I think this disqualification will not apply to you. Okay. Then 29 AE, that if you are disqualified to act as a director as per the Companies Act, and this will not applicable to a connected person. Similarly, this D also is not applicable to a connected person. So if connected person is disqualified under 29 AD or 29 AE, then you will not be disqualified. Your connected person is disqualified, but this will not apply to your connected person. Only when you are disqualified, then only you will be disqualified from filing a resolution plan here. So disqualification as a director, then if you are prohibited by SEBI from trading in securities or accessing the securities market. So in these two situations also, you are disqualified from filing a resolution plan under IBC. G is the person has been the promoter or in management or in or control. So actually you will see that in entire 29A, the term which has been used is that he has been promoter or in the management or in control. Okay, so the person has been promoter in management or control of a corporate debtor, and during his term, a preferential, undervalued, fraudulent or extortionate credit transaction has taken place. And not only that, in respect of that, an order must have been made by NCLT. Okay, so suppose a particular individual was in the management or in promoter or control of a company in which this kind of transactions have taken place, and Honorable NCLT has passed an order in respect of these preferential, undervalued or fraudulent transaction against this particular person also, then he will be disqualified. A person would not be disqualified if the above mentioned transaction have taken place. So if suppose I have taken over a new company and now I am the promoter of this company, in which erstwhile promoters, they have siphoned money, there is an order in respect of this preferential, undervalued, fraudulent or extortionate credit transaction. So then I am not disqualified because I have acquired this company through IBC process. I am a new promoter. I cannot be held liable for the siphoning away of money or happening of this type of transactions. So I will not be liable for that. So that is the reason that this disqualification will not apply if I have acquired a company and I am a new resolution applicant. Then 29AH. 29A says that the person has executed a guarantee in favor of a creditor in respect of a corporate debtor. Okay, then against this corporate debtor, a CIR application has been made by the said creditor. This has been clarified by Honorable Supreme Court as to whether the same creditor should be required to file an application for this disqualification to apply. Answer is no. We are having the judgment later. Person has executed a guarantee in favor of a creditor in respect of a corporate debtor, and against this corporate debtor, a CIRP application has been made by the said creditor, and that application has been admitted by the NCLT. So this is a pre-requirement that there has to be you have given a guarantee in favor of a creditor in respect of a CD against which CIRP has been admitted by NCLT, and such guarantee has been invoked and remained unpaid in full or part. Okay, so in that case also, this person who has given a guarantee, he will be disqualified. So what are the requirements? That if suppose X has given a guarantee to a bank in respect of Y company, then for Y the CRP process should be initiated. This particular clause says that same creditor should have initiated, but Honorable Supreme Court has clarified that this requirement is not there. And then this creditor has invoked the guarantee against the guarantor, and the guarantor has not made full payment of this the money demanded. So in that case, this guarantor will be disqualified, okay, from submitting a resolution plan in case of a company which is under CIRP. 29AI, person is subject to disabilities corresponding to section 29A to section 29AH under any law in a jurisdiction outside India. If similar kind of if from A to I, if under these provisions, if a person is disqualified pursuant to a law outside India, I think then that is also disqualified here. Then, so 29AJ. So now 29AJ says that resolution applicant has a connected person who is disqualified under clauses A to I. Okay, so till now, all these clauses were applicable to a person who is filing a resolution plan and the persons who are acting in concert with him. Okay, but here now, not only that resolution applicant, if his connected person also fall within A to I, then also this resolution applicant cannot file a resolution plan. Okay, so resolution applicant has a connected person who is disqualified under clauses A to I. So not only that person, we have to see connected persons also. Now connected persons, who are the connected persons? So if I want to file a resolution plan, so it is not that myself should not fall within the ambit of these sections. My connected persons, they should also not fall. And who are those connected persons? This is explained. This is defined under explanation 1. And it says that a connected person would mean, 1, persons who are the promoter or in management or control of the resolution applicant. So if X Limited is the applicant, resolution applicant, then X Limited's promoter or the persons who are in management, persons who are the promoters or in management or control of the resolution applicant. So the persons who are controlling the X Limited, who are having the majority shareholding of X Limited. So these will also, they should also not be having any of these disqualifications. So persons who are the promoter or in management or in control of the resolution applicant, they should also not fall within the ambit of A to I. Then persons who would be the promoter or in management or control of the corporate debtor during the implementation of the resolution plan. Okay, so one is that from the person who is acquiring this particular company, but that person says that I will be having somebody in the management. Okay, so that person who will be there in the management, he should also not be disqualified. So this is, I think, for the purpose of preventing existing managements from entering into any understanding with some other parties, and then taking or participating in the management of the CD post approval of a resolution plan. So I think this is to prevent that situation. So persons, not only the RAs, promoter and the management or the persons who are controlling the RA, but persons who will be the promoter or in management or control of the CD during the implementation of the resolution plan, they should also not be disqualified. So you have to see in the resolution plan as to who will be there in the management, who will be there as the director, who will be participating in the management. So we have to see that they should not fall within the ambit of section 29A. Then clause 3, the holding company, subsidiary company, associate company or a related party of a person referred to in the above 2 clauses. Okay, so not only the persons who are promoter or management of the resolution applicant and the persons who will be there in the management, but the holding company of these people, subsidiary and associate and related parties of these persons. Okay, so then that means that even the related party of the promoters of the RA, then the persons who will be there in the management, so you have to see that whether their relatives also, they don't fall within the ambit of section 29A. So that means as RP, we will have to examine the profiles of a number of individuals, entities which are related to the RA. But answer to that is no, that it is not that all of them, all their relatives, we have to see that whether they fall within the ambit of 29A. So this, I will come to that as to what we have to see. Then nothing in this clause shall apply to a resolution applicant which is a financial entity and is not a related party of the CD. Then who are the financial entities? A scheduled bank, any entity regulated by a foreign central bank or a securities market regulator. So here any foreign bank can be there who is having a branch in India. Any investment vehicle registered FIIs, etc. As any asset reconstruction company, any alternate investment fund. So they fall within the definition of financial entities. Then now we have seen the provisions of section 29A. So there are 4 ineligibility constructs under these provisions. What are those? First, where the person himself is ineligible. Okay, so 29A say that that person, this resolution applicant should not be ineligible as per section 29A. So we have to see his eligibility or ineligibility. Then we have to see the connected persons. And connected persons, we saw the definition 29AJ, explanation to 29AJ. The definition of connected person is, again, let's see, any person who is the promoter or in management or control of the RA. So RAs, promoters, etc. Person who will be the promoter or management or in control of the business of the CD during the implementation of the resolution plan. And third, holding company, subsidiary company, associate company, or a related party of the persons referred to in these two particular earlier clauses. Then associate company. So you are aware that this term has been defined under section 2(6) of Companies Act, which says that at least 20% of the total share capital or of business decision under an agreement. So that should be there. Then it will be treated as associate company. So holding company, subsidiary company, and associate company. Then in addition, related party also. Related party has been defined under section 524 and 524A. So 524A defines the definition of a related party with respect to an individual, and 524 defines a related party with respect to the corporate debtor. Okay, so these definitions we are aware, so I am not elaborating on the same. Fourth is where, so these were first, the person himself. Secondly, a connected person. We have to see that they should not fall within 29A. Third is related parties. Fourth is persons acting jointly or in concert, because which is the section 29A. First beginning of section 29A says that the resolution applicant or the person who proposes to acquire and the persons acting in concert with him. So person acting in or acting jointly or in concert with a resolution applicant. So these are the persons who have the common objective or purpose of acquisition of shares or voting rights in exercising control over a company pursuant to an agreement or understanding, formal or informal, directly or indirectly, cooperate for acquisition of shares, voting rights, exercise of a control of a company. So persons acting in concert are those who jointly they want to acquire a particular company, and that can be pursuant to an agreement or understanding. It can be, this understanding can be formal or informal. It may be in writing or may not be in writing, or directly or indirectly. So if they come together for the acquisition of a particular company or for the acquisition of shares of a particular company, so we say that these persons are acting jointly or in concert with the resolution applicant. So all these persons, they should be, we have to see that they don't disqualify within section 29A. Exemption, I think we have already discussed. There is another exemption also, which is section 29, which is MSME entities. So section 240A says that this limited exemption, it is allowed to MSME enterprises. So from the, and not from all the provisions of section 29A. So this exemption to MSME is only with respect to clause C and H. And MSME, who should be the MSME? It is not that the MSME who is acting as RA. No, the corporate debtor with respect to which CIRP is going on. So that corporate debtor should fall within MSME. So if he is within MSME, then in that case, the clause 6 and H of 29A will not apply to any entity. Okay. So no, not to apply to the resolution applicant. Resolution applicant can be anybody. Okay. So those resolution applicant, if they are disqualified under under clause C and H, then in that case, this disqualification, they will not be treated as disqualified, provided CD falls within the ambit of MSME. Next is the indicative due diligence checklist. I think before that, let me see the judgments, what these judgments are. So most important judgment is Swiss Ribbon Private Limited and another versus Union of India. So this was 25th January 2019 Honorable Supreme Court judgment, and Honorable Supreme Court upheld the constitutional validity of a number of provisions of IBC, including section 29A. So with respect to 29A, you know that a number of challenges were made, a number of issues were raised, and these issues were mainly vested right of a former promoter to participate in the revival process of a corporate debtor. So the issue which was raised was that section 29 is disqualifying all the promoters. Though they promoters, they are having a right, vested right to participate in the revival process. You know that under BAFR, the first right was given to the existing promoter. So existing promoters were allowed to file a resolution plan, or which we used to call rehabilitation scheme. And if he fails, then the proposals were invited from general public for takeover of management of the sick company. But here, Honorable Supreme Court, so this issue was raised before Honorable Supreme Court that they are having the first right to participate. You can't disqualify them. Then a blanket ban on the promoters of the corporate debtor. They said that you are imposing a blanket ban on all the promoters of corporate debtor. In no case a promoter can participate, because in all the cases accounts will be NPA and other disqualifications will apply. Then the period of 1 year specified under section 29A is wholly arbitrary and without any basis in law. So this was another objection against 29A. Restrictions on related parties or promoter. They said that you can restrict at the most the promoter. You can't restrict their related parties. So these were the four major issues which were raised against section 29A before Honorable Supreme Court. Then the Honorable Supreme Court then observed and stated. So this is very important, and I will read for you the relevant portion of the judgment, because I think that will help us understand this particular section. It was noted that the promoter of the CD does not hold any vested right to bid for the property of the corporate debtor. Honorable Supreme Court said that you are not having any right, that you must be given a right to participate. They said no. Then it was clarified that misfeasance was not the sole ground for disqualification under section 29A. So the plea was taken that if somebody has done misfeasance, so then you disqualify him. It is not why other disqualifications are there. If somebody has siphoned away money, so then you hang him. You don't allow him to participate. But why other clauses were there? So Honorable Supreme Court said that misfeasance was not the sole ground for disqualification, as the instant section specified other grounds based on which a person could be ineligible to submit a resolution plan. They said that as per our public policy, we don't want to allow other undesirable persons also. So it is not that only when he has siphoned away money. They said no. So other grounds are also there on the basis of which we don't want to allow. We treat all of them as undesirable person, and we don't want to allow them to participate in this process. Then period of 1 year allowed under 29AC was based on a RBI circular on prudential norms. As Khurana ji said, that this is based on that RBI guidelines, which is correct. Honorable Supreme Court said that it is based on that RBI circular, and it was held that period allotted was not randomly mentioned therein. Then 29AJ read with, this is very, very important. 29AJ read with definition of related party as laid down in section 524 and 524A. Validity was upheld. In order to be disqualified under section 29AJ, the related party must be connected with the business activity of an applicant. Okay, so this is the answer to that question. Whether all related parties have to be disqualified? Answer is no. Honorable Supreme Court said that related parties must be connected with the business activity of the applicant. Okay, and why this Honorable Supreme Court said that, that is also there in the, when I read the relevant portion, you will understand that. The person who act jointly or in concert with others are connected with the business activity of the RA. So if a person is intending to acquire a company, the persons who are jointly working with him, jointly who are having common business interests, so they are disqualified if they fall within 29A. And then they say that it is not that all their relatives will be disqualified. If their relatives, they are participating along with him and are having common business interest, so in that case they can be. A further elaboration is there. 29AC not restricted to malfeasance. Various clauses of section 29 issues that a person need not be a criminal in order to be kept out of the resolution process. So this was the answer of Honorable Supreme Court to the challenges which were made to section 29A. Then I want to read this particular thing, the relevant portion of the judgment. I think this will be clarifying our doubts about this one. We are of the view that persons who act jointly or in concert with others are connected with the business activity of the resolution applicant. Then similarly, all the categories of persons mentioned in section 524A show that such persons must be connected with the resolution applicant within the meaning of section 29AJ. Then, this being the case, the said categories of persons who are collectively mentioned under the caption relative obviously need to have a connection with the business activity of the resolution applicant. In the absence of showing that such a person is connected with the business activity of the resolution applicant, such person cannot possibly be disqualified under section 29AJ. Okay, then all the category in section 29AJ deal with persons, natural as well as artificials, who are connected with the business activity of the resolution applicant. So this is very, very important, that connected persons. Let's see who are these connected persons again. Let's see 29AJ. So explanation, connected persons would mean persons who are the promoters or in management or control of the resolution applicant. So definitely they are connected with the resolution applicants. Then persons who would be the promoter or in management or control of the city during the implementation of the resolution plan. So these will be the persons who are connected with the resolution applicant. That is the reason that he is installing them in the management of corporate debtor. Then holding company, subsidiary company, associate company, or a related party. So Honorable Supreme Court says that when we are talking about clause 1, then clause 2. So these are the persons who are connected, having business connection with the RA. And then the beginning of section 29A also it is mentioned that the RA or the persons acting in concert with that. So all these people, they are having business connection, close business connection with the RA, then only they will be disqualified. So while interpreting this one, the 3, holding company is also having close business connection, subsidiary company, associate company also, and then related party. So Honorable Supreme Court says that here related party has to be, the meaning of the same has to be made in the context. So all other people here, all other entities here, they are having close business connection. So here related party also means only those related parties who are having close business connection or are acting in concert with him. So let's go back to the definition, that particular portion of Honorable Supreme Court. Then all the categories in section 29AJ deal with the persons, natural as well as artificials, who are connected with the business activity of the resolution applicant. Then the expression related party, therefore, and relative contained in the definition sections must be read nociter is sociais. इसका मीनिंग क्या है? Nociter is sociais. इसका मीनिंग है, it is a rule of interpretation which says that the meaning of an unclear or ambiguous word, as in a statute or contract, should be determined by considering the words with which it is associated in the context. So nociter is sociais. This is the term. Honorable Supreme Court says that this rule of interpretation will apply. The word relative, which is mentioned under clause 3 of explanation to 29AJ, will mean only those who are having close business connection, not all relatives. And that is the reason you are aware that in the case of SR Steel Limited, SR Steel Limited, Mr. Alan Mittal, he was the resolution applicant, and I think he is having some related entities or relatives who are having companies who are having NPAs for more than 1 year. So in spite of the same that fact, very close relatives were falling within the ambit, but that will not make Mr. Mittal as ineligible. Okay, so this was the interpretation which was applied, that not all relatives should be considered for the purpose of this 29A eligibility or ineligibility. Only those who are having close business connection and who are acting in concert with him, okay, would include only persons who are connected with the business activity of the resolution applicant. So this clarifies this one. Otherwise, we are having doubt that we have to see all the relatives of the resolution applicant. We have to see whether they fall within 29A or not. No, we don't have to do that. Only those who are having, who are doing business, who are his partners, or who are closely connected in his business activity, I think they only need to be considered. Their disqualification has to be considered for this purpose. Then we are having Chitra Sharma and versus Union of India. In this particular case, the promoter, this was, you are aware that Jayaprakash Associate Limited was treated as disqualified because JL was classified as NPA. JL was the promoter of JIL, and Jayaprakash Associate Limited had an account which was classified as NPA for a period of over 1 year from the date of commencement, and it was the holding company of JP Infratech Limited. So they were disqualified. So JIL happens to be a promoter of the CD against whom an order had been passed by the AA in connection to irregular transaction within IBC. Additionally, it was noted that JIL lacked the financial capacity. Then we are having ArcelorMittal case. Okay, the apex court observed that it is a see-through provision and the de facto position of person has to be checked as opposed to de jure. Okay, so it is not that somebody is your brother and he is disqualified. No, you have to see actually whether he is your partner or whether he is doing business with you. So not the de jure, you have to see the de facto position. It is important to discover as to who are the real individuals or entities who are acting jointly or in concert and who have set up such a corporate vehicle for the purpose of submission of a resolution plan, and not the persons who are, as per law, who are his relatives. If they are not participating with him for this particular acquisition, then their disqualification will not matter. Acting jointly does not mean a JV necessarily. It is the sense of coming together. Then stage of ineligibility attaches as the time when the resolution plan is submitted. Control denoted only positive control. This is another important thing, that if suppose the resolution applicant is having a corporate debtor who is a defaulter, but this resolution applicant is holding only 26% equity. So he is not having, though he can stop the company to pass a special resolution, but he is not having a positive control. So Supreme Court in this particular case clarified that the control here means positive control, where you have the authority to decide and not only to stop the company from making a special resolution. No. So control means positive control, where you can have the things, you can make the things happen, or you can take decisions, not only to stop this. Arun Kumar Jagat Ramka, yes. So that Supreme Court says that under section 230A also they will be treated as disqualified if they are falling within the ambit of section 29A. MBL infrastructure also, this was the judgment where they clarified that 29AH. So 29AH, the word which is used is such creditor. So Honorable Supreme Court in this particular matter clarified such creditor in this provision will include all creditors of the corporate debtor, or just the creditor, or not just the creditor who has invoked the insolvency process. A purposive interpretation of the provision, the apex court held that the disqualification under section 29AH of IBC will stand attracted on mere invocation of personal guarantee by a creditor, notwithstanding the fact that insolvency process was initiated by another creditor. So 29A says that the same creditor should have initiated the CIRP, but here Honorable Supreme Court says that no. So against that corporate debtor, CIRP has been initiated, and then any creditor who has invoked guarantee of this particular guarantor and the guarantee is not fully repaid, then in that case the disqualification will be there. So no, it is not necessary. The creditor who is invoking the guarantee, he should have initiated the insolvency resolution process of the corporate debtor. So this is MBL infrastructure. I think very quickly we can see as to what due diligence is to be conducted. An undischarged insolvent, for determining the same, I think we have to rely upon the affidavit which we will be obtaining. Then Google search we have to make, and then from IBBI website also we can determine if there is any information whether this particular bankruptcy process has been initiated against a particular individual. Then willful defaulter. So for that purpose, these are the this is one website, suit.sibyl.com. Then Google search can be made. Willful defaulter list issued by different lenders. So we have to see who are their lenders, and then we have to see the list which is being maintained by them. Then auditor's report under CARO. So if we want to determine with respect to a particular company that whether this company is a willful defaulter, so auditor's report under CARO will help us to identify whether he is a defaulter. Okay, so you know that under CARO, with respect to companies, an auditor has to give details as to whether he has defaulted to any bank, institution, and in respect to some other liabilities. Okay, so from there we can get an idea that whether this particular company is a defaulter. If it is a defaulter, then definitely we can look for this suit.sibyl.com or willful defaulter list of the maintained by the particular lenders. Then this one 29AC, submission of the resolution plan. This is whether that account is NPA. So similar things, suit.sibyl.com, Google search, auditor report, to determine whether he's a defaulter, and then we can even ask him to give a CIBIL report. So these are the sources, and then with respect to other clauses, section 29AD. So whether he has been convicted of any offense, so SCC online, Manupatra, Google search, and then affidavit from him, is disqualified to act as a director under the Companies Act. So MCA website, we are having these details, and if we can apply the test that if his DIN is operative or if DIN is active, then that means he's not disqualified. I think as soon as a person is disqualified as a director, I think his DIN is made inactive. Okay, so if DIN is active, so that we can determine, and if DIN is active, we can I think consider him. We can consider that yes, there is no disqualification order against him. Then SEBI is prohibited by SEBI. So for these purpose, SEBI, these lists are available with BSE and NSE, the individuals who are disqualified from trading and from accessing the security market. So we can, I think, refer to these lists which are there on BSE, NSE websites. Has been a promoter or in management or control of a CD where preferential transaction. So there also Google search, then in about the CD in which RA is having control, and affidavit, and from website of IBBI on Honorable NCLT website, whether any order is there passed against him. Has executed a guarantee in favor of creditor. So Google search about the companies with whom RA is associated, balance sheets of these companies we can see, and we can even ask them to give CIBIL report, affidavit also. Any disability under section 29AI, so affidavit, and then we can identify the countries where RA is having business interest. We can make Google search also. Then 29AJ, so connected persons. So we have to first identify who are the connected persons based on RA's balance sheets and the balance sheets of connected entities. persons mentioned in the resolution plan who will be there in the management and control of CD. So we have to make some due diligence in respect of those and individuals who will be there in the management after plan is approved. We can take undertaking from them, MCA record, and all those checks we have to apply to these identified persons who are connected persons. So I think with this I can close my today's session. If you are having any questions, then I think I will be there, Manoj ji will be there, Mr. Khurana and Mamta ji will also be there. I close this particular presentation, and then let's see if you are having any question. Thank you very much, everybody, for participating.
Thank you, Nilesh ji. Thanks a lot for the wonderful presentation. I must say that with your presentation, at least person like me will be ready to take up the assignments for due diligence. That is one thing I can do.
So I think then I can raise a bill on you for 25% or 30% of the fee which you will be getting. Okay?
Certainly, sir. It was a really wonderful thing. Let me tell you.
Thank you.
Keep on doing various type of activities, and the way you have explained and the way you have chalked out a list of due diligence, it is really wonderful. Really, really wonderful. I really appreciate that for sharing your this knowledge, because this knowledge not only comes from the experience, and you are sharing each and everything over here. That is really nice of you.
Thank you.
Manoj ji, I think we can go in for a panel discussion now. And now I will invite our panelists, Nilesh ji, Manoj ji, and Mamta ma'am, along with Rajiv sir, to have a detailed discussion, panel discussion, and also try to answer some of the queries which have been raised on the messages box, chat box. So over to you, Mamta ma'am, Manoj ji, Rajiv sir, and Nilesh sir.
Okay.
Sure, thank you. It was a great presentation. I think, I mean, amazing. Manoj ji, the way you actually gave us the whatever developments that has happened in the last 1 month, it actually helped us to recap. That was really good. Rajiv ji, thank you so much for all the inputs that you gave. And Nilesh ji, the presentation was really good. I must tell you, this securities thing that you mentioned, that if the loan is getting converted into securities for a financial institution, then it will not fall under this disqualification criteria. This came out of the case law where I was handling. It was Deccan Chronicle versus Shrey.
Okay.
So that was one of the matter. And Arun Jagat Ramka ji matter is being done by Sumit.
I know. Yes.
Section 230.
Correct.
That was a long fight.
Right.
The Honorable Supreme Court said that no, in 230 also it will be applicable.
Yes.
If all the ladies and gentlemen who's listening us, you will be aware that Section 230 was taken as a mechanism in the beginning, that if the promoter is getting stuck in 29A, then why not give a scheme of arrangement under Section 230 of the Companies Act? But Supreme Court actually put a stick in the beginning and said, no, it will be applicable there also.
Right. So let's see the questions. So one question is, in case of 29AG, if RP files Section 43 application, which is still being heard, then such director is not disqualified. But if NCLT admits such application after the plan is approved by COC, then should the RP rerun the process, or should the second highest RE's plan should be again considered by the COC? So I think, Mamta ji, will you answer?
This is actually a tricky question. So I'm also going through the same thing. In fact, on the date of EOI, we try and see whether see, I understand your question. I'm just trying to practically view it. So this is a very big question mark, but I want to practically tell you that when the COC gets any report where the transaction auditor has opined that there is something in the company which actually needs to be filed by way of avoidance transactions, then the COC kind of is never serious, even if the ex promoters give a resolution plan. I have seen in experience that they actually write it in the minutes also while they discuss the matter, that because the RP has opined or the transaction auditor in his report has mentioned some gray areas, they say that they are not keen to go ahead so much with the promoter's plan, even if it is a maximization of value. So in that case, even if it is H1, H2 and not H5, anyways, we have to now vote on all the plans as per the latest IBBI movement, but they are then not keen. They make sure that the plan is not going through.
Right. And very tricky situation where,
Yes.
but I think if as on the date when resolution plan is being considered, he is not disqualified, or only subsequently there is an order, I don't know whether that will be applicable with effect from the I don't think it will apply.
Not apply actually.
In future only it will be applicable.
Yes.
Huh?
Actually, sir, the COC is also fearful. They don't want to run the whole process again.
Correct. So they don't consider, huh?
Yes.
Then a connected person. Another question is from Mr. Devar Konda, which is connected person in case Mr. Anil Ambani does not have direct business connection with Mr. Mukesh Ambani, but if they, I don't know whether it is. Mr. Ravi, your question is not complete, I think.
So Nilesh, I think he's asking that.
No, sir,
yes. If they have common investment through the holding company, are they treated as having connected entities?
Yes.
So this is the question. I think who will Rajiv ji, you will answer.
So basically, because it is the connected person, they will be treated as connected person because they are having the common investments in the holding company.
But I think in this matter, they got a different judgment, no, sir? Rajiv, sir?
Yes.
They got a leeway. They got a leeway because they were estranged brothers. So I think they got a leeway from the court that they will not be treated as connected persons.
So basically, they have to go back into how the transaction has took place. Only then, if they are not the connected persons, only then they will say. Because we have to go beyond that. That's
true. For example, if there is an estranged wife, if there's a divorce, there's a case in Big 12 matter. So if there's a divorce between a husband and a wife, so they are not then falling under the list of relatives, even if that divorce is very recent. In that case also, the Supreme Court has said that even if they were husband and wife even up to last year, but because they are estranged now due to legal divorce, they will not fall under the list of relatives.
But and then in addition, we have to see that whether they are acting in concert.
No, definitely you have to see that.
So here also,
etc.
Yeah, here also, if they are acting in concert for acquisition of a particular entity, I think then only. So they are having different or separate business interests now.
Absolutely.
So I don't think they will be disqualified or qualified based on this relationship.
And Nilesh, how can you as a RP or me as an RP can find out that whether they are acting in concert? You have to just take faith on the undertaking.
Yes, undertaking. Yes, definitely.
Right.
Yeah. Then I think let me see if any other question here.
Yeah. One question is there.
Can a non-promoter, non-executive director of CDB continued as a director after the RE takes over the CD since such director has experience in the business operations? Mamta ji?
So if they have experience in business operations, then how do you say that they are okay? So I don't see any reason why they cannot continue.
Yes.
Yes,
they can continue.
I don't see any reason why they cannot continue.
Okay.
They can continue.
So we have to see provisions of section 29A. And according to that, only if he falls within any of this ambit of any of these clauses, then only. So because we have to see that
but it is not advisable. It is not advisable.
Persons who will be there in the management after approval of a resolution plan. We have to see that whether this particular person will be falling within the ambit of any of this. So I think he may fall. Though he's a non-promoter director, but I think people who are in management also.
No, sir, they are okay. So if you say that the entire board of directors is in management, then definitely yes.
Yes, I think he will be disqualified
So
because
we have to see the
whether-
whole scenario.
Correct.
Then we will be able to judge.
Even the independent directors, they have the responsibility of management. So they can't say that we are independent, we are non-promoter, so we are not having the responsibility of management, or we are not in management.
And it is not advisable also that he should continue.
Yes.
My question is this: can you believe that this 29A is not a big hurdle under IBC for the to get the resolutions done under IBC? Or if I say vice versa, you are giving a back-end entry to the promoters under the garb of this 29A. Why should this provision is there? Why the promoters are not to be allowed, if they are fair, to give the good price for the assets of the company?
Hemant ji, acha, I think Mamta ji.
Mamta ji.
Okay. So Hemant, as you know that even now, Honorable Supreme Court has upheld the validity of this particular section 29A. So these are the undesirable persons. So if suppose somebody is there in the management and the company has defaulted to the lenders, and accounts are NPA for more than 1 year, if we consider this particular clause only, then the policy decision, or it is our public policy that this type of persons, they should not be allowed to participate. They should not be allowed to again take over the company. Okay, so I don't think that only because they are hiring the maximum amount, they should be allowed to participate. And that is the reason, you know, that this why this provisions were inserted in this law. 2,50,000 crore was the NPA of the 12 accounts, and the government did not want them to participate, or did not want them to reacquire these companies for a much lesser price. Okay, so you have been responsible for the sickness of the company or for the defaults, and then you are again coming back, and then you are acquiring at a fraction of the total debt of the company. That is, I think, I don't think there is anything wrong with that. Mamta ji, you wanted to say something.
So government has taken care of both the sides. If you see section 240A, Hemant ji, there the government has said that if you're an MSME and if you're not, they gave you leeway for 2 subsections also, and they said you can very well come from the front door. So there is no concept of backdoor here. The government is not promoting anything. The government said that if there is malfiase, if there is something wrong that you have done with the company, you should not be given the driving seat again. But at the same time, it said that I do realize that business is all about entrepreneurship and risks can fail. In that case, if you are such a bona fide promoter, and definitely you know, Hemant ji, that these days almost 99% of the entities are if not more, are falling under the MSME category. So under section 240A, the government has anyways given as a leeway to come back. And now you also have PPIRP, prepackaged insolvency resolution process.
And besides this, one thing I would like to add, basically the compromise settlement scheme under section 232 of the Companies Act, it also allows the promoter to come into the picture. And they can also give the compromise settlement proposal. Correct.
You have OTS also. Imagine there are a lot of other ways by which the promoter can go to the banks and, read. What should I say?
The banks are also having the OTS settlement scheme.
That's what I'm saying.
They can also have a word with.
Why should I am saying so? In one of the cases, the 29A hurdles, we cross it. There are 8 or 10 resolution plans which we have received, and we have gone through these long exercises. And the promoters, not only 29A, because they are debarred under that, they entered into a settlement with the banks under regulation 30A or 12A. If you are aware of 30A, that said that after publishing of EOI, they are having the right to settle their matter with the lender. So now when they settle their matter with the lender, the whole exercise of 29A has gone through. So they have taken out the another route to come into the company. Therefore, I am saying, and you are also answering it, that the promoters are also having got a chance under 240A to come and propose their resolution, then why should this 29A is a big hurdle for the RPs? If they are having a chances under 240A, under regulation 30A, and under the semi scheme which sir has said so. So if they are giving so much of entry to propose their resolution plans, then why should within 180 days the RP should be dragged down to for this responsibility of 29A? That is my question.
So you are having a point, Hemant, that we are not allowing the existing promoter to participate in this process, even if they are they are offering the maximum amount. But after you have run a resolution process and then promoter he goes to the lenders with a better proposal, I think lender can still accept their his proposal.
Yes, sir.
And then under section 12A, I think that they have that option.
Yes, because the 90% of the COC members they can give the resolution.
Therefore, I am saying if 29A objective of the legislature to not to allow the promoter to come and propose their resolution plans, and therefore 29A, but there are other ways also, like Mamta ji said 240A, sir said scheme and 12A. Then what is the purpose of 29 to be on the head of the resolution professional? Everybody should come and give it their proposal, and whosoever give the best, whether the section and sections are immaterial, whether it's 240A, whether it's 29A, meaning thereby, if you are giving a chance to everyone, if suppose promoter are giving under 240A and he is offering 10 rupees and I am coming under as a 29A, I am offering 20 rupees, then who will get this company? The lenders will always go by with the 20 rupees, where the maximization of the value.
No, but it is 20 rupees. You have to measure it vis-a-vis 200 rupees, right? Everywhere you have to measure it vis-a-vis 200 rupees, Hemanji. I don't think let's not get into this argument.
No, I'm not arguing.
I'm
just trying to, because I'm practically handling so many of matters. So this question always disturbing me.
I understand.
So, because 29A, Mamta ji, is a big process for the RP to be executed within a short period of not less than 15 days, because time period is running so fast. Therefore, I am saying, and after that, if any proposal come under 240A or 12A or 30A, everything become just an exercise.
I agree.
That is only I'm discussing.
But Hemant, there is a difference, Hemant. For approval of a resolution plan, you need the consent of 66% of the financial creditors or the financial creditors. For the purpose of 12A, you need the approval of 90%. If 90% of the creditors they are approving the proposal of a promoter, I think that should be allowed. That should be. I think that is the reason that it has not been made applicable. 29A has not been made applicable to 12A. Reason is that because a substantial part of the almost all the creditors, they are jointly taking a decision that yes, this proposal should be considered. I think that can be one justification.
Only one suggestion: it should be diluted to some extent that the promoter, like connected persons, that is a very tough exercise. I am talking on behalf of RPs. That is for our, because everyone put a responsibility. In some of the cases, the court said only taking an affidavit is not your job. You have to go through each and everything, because you know the way of the courts are working nowadays.
But you have to do some due diligence, and you have to, I think, have the evidences that you have conducted some.
Correct. Not only relying upon the affidavit. So it's a big exercise, and later on you find out that promoters are coming by way of 240 or by way of 12 or 13A, irrespective of the fact that the percentages are there. Therefore, I am saying, why should this is so strict for the RPs on their head? It should be some kind of reasonable should be by the legislature nowadays, because earlier I agreed it was come in 2017, we are in 2022. So it should be diluted in some way so that we can get a more resolution for this in these IBC matters. Only that my concern to be shared with the members.
Okay.
But the government has a courtesy that it will be abused also. That is the reason that 29A, even the compromise also, it has been held to be legally valid. In the case of liquidation, I mean to say.
Sir, a small distance, sir. In case of a 12A, the promoter is paying from own funds. Whereas in case of a regular plan, he can also pay from the company's funds. Maybe that is the reason why 29A is not applicable for a 12A situation.
Ravi sir, even for 12A, the promoter can get funds from anyone.
Anywhere. It is only the payment
Not
only.
necessarily that it has
But not from the company, no, madam. Not from the company.
not from the company,
So
definitely.
that's why the difference.
No,
So
Ravi,
So
it may
even
be-
in case of resolution plan under 240A, he cannot be paying from the company's funds, sir. Ravi
when
sir,
a plan-
in that
no, when a
case
plan-
Basically for source of funds, he can even dilute his shareholding also, and he
Yes.
can have the investor also.
True.
It is allowed.
No, sir, but in case of a plan, if the plan is given for over a period of 3 years or 4 years, normally the source, part of the source are from the operations of the company.
but
at the point of giving the plan, at the first instance, at the very threshold, he has to show that the entire money is going to come from outside. After he gets in, because he's not going to get the control before that 4 years period. So Ravi sir, unless the plan is fully consummated, so for 4 years, if he gives a plan, he will not get the control of the company till the end of the 4th year.
But
So he will
Mamtaji-
not be able to use, right, Nilesh sir? He will not
but
be able to use the fund of the company.
No, madam,
No,
RA
Ravi
gets
ji-
the control. RA gets the control of the company. Only thing is charges may still be in the favor of the existing creditors. No?
Actually,
That's what
Ravi ji, actually, for the under a resolution plan, also you can propose that you will sell some of the assets. You will be bringing in money definitely, but at the same time, some of the surplus assets you will be disposing of and then paying the dues of the secured creditor. I think then that can be part of a resolution plan. Similarly, when a promoter is giving a settlement proposal, he can say that some upfront amount he will be paying, and he can also propose that some of the assets he will be disposing of, and then rest of the amount will be paid. So I don't think there is any difference here, and both the under resolution plan also and under settlement proposal also, the assets of the company can be utilized. Some of the surplus assets can be sold, and even in the settlement proposal also, though what is happening is that most of the lenders, they don't accept any
Yes.
plan where repayment is made over a period of time. So in most of the cases, we have seen that upfront money is paid and that money is brought in by the promoters from outside sources. But I have seen resolution plans where promoters, they say that some money they will be paying out of sale proceeds of some of the land or some of the machinery like that.
I mean, another thing is that in the 12A, there is no waivers. So entire creditors continue, these people continue. So why I was trying to say is that the section 29A is not made applicable to 12A because of these peculiar situations for 12A.
Right. I think no more questions are there.
Yeah, Nilesh ji.
Shall
I think
shall
we can close the session now. For formal vote of thanks, I would request Mamta ji to present a formal vote of thanks.
Thank you for giving me this privilege. It's an arduous task today to really propose a vote of thanks to such elite speakers who actually not only spoke from the textbook, but it felt that whatever they have learned over a period of 30-40 years, uski puri nichod aaj is session mein hame dikhi. So that is not easy to really bring out in words. Sometimes professionals learn so much and earn so much of experience, but actually putting it in words and expressing it in front of a elite gathering is very difficult. But today we found Rajiv ji, Manoj ji, Nilesh ji, and everyone who were speaking on the subject actually did extremely well, and they expressed it too very well. All the participants must have been hugely benefited. Manoj ji, as the president of IIPA, is really taking a lot of efforts to put this association. Definitely he has a team, but I always have felt that the engine is very important to a train. Manoj ji is that engine who really drives this train of IIPA. I won't say single-handedly because he will not like it, but he always likes to take all of us together and he drives it very well. Thank you, Manoj ji, for all that you do for IIPA and for the benefit of the entire fraternity. And thank you, Rajiv ji, Nilesh ji, Navneet ji, and everyone for all the efforts.
Yeah,
We
before
have a very-
Mamta ji,
Yeah.
please carry on. Before you
No, I
just
just
would
also
like
wanted to say thank you to the Secretariat of IIPA. Yes, Manoj, over to you.
Yeah, before we end, it was a wonderful session. In fact, in my practical experience, I did not come across much of 29I proposals. Two things are there. One is that we are having a meeting with IBBI chairman in coming Tuesday. If any one of us, any listener or any one of us can enlighten us with some points that which from the IP community point of view, we should put forward before them, he can write to us. He can, put that particular points to us in the WhatsApp also, and even in the chat also. Rajiv sir has already said, something to me. We have discussed that internally, and we are collecting similarly more points also. And when we shall take a call for all those points, definitely we shall respectfully look into your point also. One thing. Second thing is that we always encourage young people to act as a speaker or moderator also. In fact, I put this thing in my WhatsApp group also. I received 8-10 people's interest in this thing there. Similarly, I invite again here also that if anybody is interested to act as a as a moderator or a speaker, he is most welcome. IIPA will provide them a platform to enlighten our knowledge. In fact, I should say our knowledge and increase his or him personality also. We all people who are seniors are sitting there. We also started one or the other day as a beginner only. But with the passage of time, we developed, and I would like young IPs who are keen to develop their personality as a speaker or moderator, or maybe as a research associate also. They can join us, they can contact us, and we shall provide them the platform and and wish them all the best also. This is what I want to say. I hand over to Mr. Nandiji. Now, please carry on.
Thank you, Manoj. Thanks a lot, ma'am. Thanks a lot, Rajiv sir and Nilesh ji. Wonderful presentation. Ravi sir, thanks a lot.
Thank you.
Bringing up Ravi sir and Hemanji for bringing up contentious issues. So with this, I think we should conclude our session. And thanks a lot to everybody. Thanks a lot, Manoj.
Thank you very much. Thank you. Thank you very much. Thank you. We're thankful to the Hemanji also for raising critical issues and making us to delve into it, and for which I think very well answered by Rajiv ji, Nilesh ji, and Mamta ji. Thank you very much to all four to you, and we expect that in the future also. In fact, we're thankful to Mr. Ravi also that this sort of participation really enlightened everybody in the meeting. Thank you very much. Thank you.
Thank you, sir.